Good afternoon, and welcome to the Appellate Division First Department. Most of you know how we work. I'm going to call the calendar and ask for your requested argument time. Please be cognizant of the fact that I already have 6 hours of requested argument time, so adjust your request accordingly so that I don't have to. Understand that your request is for you, so that even if I cut your time, and I likely will, if my colleagues have additional questions, I don't interfere with that. So that if you are brilliant, you'll get extra time, okay? All right, that being said, People versus Martell. Good start, submitted. Van Dyke versus US Bank.
Respondent, Tom Curtis.
And how much time would you like?
Sorry, how much time?
Time.
10 minutes?
You weren't listening to my speech, but go ahead. Okay, 6 and 1 and 6. D. Antone versus Kyra P. Submitted. Gaon Wellness versus GI. No one, okay, I'm gonna say it again. We have 6 hours of requested argument time. Okay, so how much time would you like? 5 and 1 and 5. Mangio, I'm pronouncing this name incorrectly, I'm sure. SR Taxi Corp. Okay, and how much time would you like? 10 minutes. Everybody's suffering from the same problem. 6 and 1 and 6. Brown versus 39 Spring Street. Guys, I'm not kidding. No 10-minute request. There is no case on this calendar that has a 10-minute issue, okay? So,
Appellate request 7 and 2.
okay. 6 and 1 and 5. Brown versus 39 Spring Street. Oh, sorry. You see, they messed me up. People versus Fabian Koch. Okay. 7 and 2 and 5. Owen Steele versus City University of New York. Okay. 5 and 1 and 5. Coutron versus Cruz. Okay, submit. Have a seat until the call of the calendar. Rossi versus Doka, USA. Okay. Okay, so the respondents both have very similar issues, okay? So I'm going to do 5 and 1, 3 and 3, and again, we will have additional questions. It may go above that, okay? All right. Dwyer versus Dwyer. Okay. 5 and 2 and 6. See, when you're reasonable, you get what you want. Wesco Insurance versus Cookman. Okay. 5 and 2 and 5. Georgie Visky versus Robbins. Okay. 5 and 1 and 5. People versus Christian Cummings. We will accept that. Thank you. GMF 157 LP versus In Spirit Development. Yes, and we are arguing both cases together, so go ahead. Okay? 7 and 1 and 5. Okay, first case on the calendar to be argued is Van Dyke versus U.S. Bank. Anyone who has already submitted can leave now. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Jacqueline DeChico of J. Robin Law, and I represent the appellant in this matter. This appeal seeks to reverse 2 orders and 1 judgment of the lower court, all of which ultimately apply the Foreclosure Abuse Prevention Act, which I will refer to here and during the argument as FAPA. And in so applying FAPA, ultimately held that the mortgage or the statute of limitations to foreclose on the mortgage expired. Unless the court has specific questions for me pertaining to my arguments as to retroactive application and constitutionality of the statute, I will leave those arguments on my papers and I will address specifically the unique issues as it pertains to this case.
Okay?
Even if the court applies FAPA here, the statute of limitations to foreclose did not expire because there is an express judicial determination that the 2009 foreclosure action, or an action that was commenced in 2009, was ultimately discontinued by stipulation which was so ordered by the lower court in holding that the plaintiff...
So a so ordered stipulation is now a judicial determination?
Correct.
Because a judge signs off on an agreement between parties, that now becomes a judicial determination that would do an end run around the statute.
Well, a stipulation that is so ordered would be a judicial determination, yes, Your Honor. It wouldn't be a runaround.
What case so holds?
I do have it if you give me one
Good,
moment.
I'm glad.
And I believe it is Steele. Yep, Steele versus Motor Vehicle Accidental Indemnification Corp. at 39 AD 3D 78 Pinpoint 81, First Department, 2007.
So pre-FAPA.
Correct.
Okay.
Correct. Well, the stipulation was pre-FAPA as well, and I mean,
Yes, but the statute was very clear that wherever there was a case that had not reached final determination or enforcement of a judgment, that FAPA would apply. So by the clear reading of the statute, based on our case law in this department.
CPLR, and I believe it is 213, specific provision here. Yes, it is CPLR 213 sub 4. It adds subsections A and B, which basically state that a defendant or a plaintiff, in this case we are the defendant, is stopped from asserting the statute of limitations defense unless there is a judicial determination that holds, that basically says that acceleration has been revoked. And here we have a stipulation of discontinuance.
And that stipulation said what?
The stipulation of discontinuance, it's at page 116 to 117.
What did it say?
It states that based upon the orders of the lower court dated February 14th, 2019, and of the First Department dated February 14th, 2020, that based upon those orders which held that the Bank of New York, the plaintiff in the 2009 action, did not establish standing or did not have standing in the 2009 action. Based on those orders, the
I'm sorry, those two different concepts, that the defendant failed to establish that it had standing on the one hand, as opposed to finding as a matter of law that the defendant lacked standing.
Understood that it was an order on a motion for summary judgment, not on a motion to dismiss brought by the defendant in that action. It was on a motion for summary judgment that the Bank of New York failed to establish that it had standing.
And the effect of that is to, the upshot of all of that is there's a tribal issue of fact then as to standing.
Correct.
Okay.
And the parties did agree, based on those two orders, that should the case proceed to trial, it would have been a waste of judicial resources because the lower court would have ultimately held that the Bank of New York Mellon did in fact lack standing. to avoid,
So your stipulation, assuming that that's what we would hold, now equals a judicial determination that, again, does an end run around the statute, FAPA?
the
That's
stipulation.
what you're arguing. You're saying because you would have found this, we should therefore be able to do an end run around FAPA.
And really, it's that you decided to stipulate to discontinue the action, believing potentially that the court would make a certain determination, not that the court in fact did make that determination, right?
Well, it is not that we believed that the court would find. It is in fact that I say my client because I also represented them in the 2009 action, but on the basis that Bank of New York did in fact lack standing. So proceeding
But the
to
court
trial.
didn't determine that. The court just determined that there were questions of fact relating to that.
The court, right, and that is correct. I am not trying to argue that that did not happen. It is based on a denial
So
of a
since
motion
it's
for
not
summary
issue
judgment.
determination and it's open-ended, you can't say that there's been a final determination regarding that.
So no, I am not arguing that there's a determination in those two orders that establish that it lacks standing. The determination
You're
is,
saying that by your client recognizing you would lose on the merits eventually, you enter into a stipulation in the hopes that that stipulation would somehow be a life raft for your case. That's what you're arguing.
no, Your Honor, because at the time that the stipulation was entered into, it was Freedom Mortgage Corp versus Engel, which was the law of the land at that time, that basically said that a stipulation of discontinuance nullifies an action as if it had never been, and therefore, the law in effect at that time held that you could revoke acceleration through stipulation of discontinuance alone. It was not a runaround. The parties had agreed to, and the intent behind the stipulation was that based on Bank of New York's lack of standing, that the 2009 action would be dismissed. The stipulation is clear in that it states that based upon those.
I get it. We can read. We know what the stipulation says.
And that was the
Okay?
party's intent.
We get it. You'll have time on rebuttal.
Thank you, Your Honor.
You may
Morning.
proceed.
Good afternoon. May it please the court. Tom Curtis for respondent. The FAPA issue
Was the stipulation a judicial determination?
no.
Why not?
And in fact, because summary judgment does not establish any fact. Summary judgment simply establishes that there's an issue of fact for trial. And I will simply say that in this particular instance, there was an assignment of the note and mortgage several weeks after the foreclosure action had been commenced, that the plaintiff in the foreclosure action could have come up with a witness to testify that the note was physically delivered to the bank prior to the commencement of the foreclosure action in 2009. The problem they had was they didn't have such a witness. And that's why this stipulation was carefully worded to recite the terms of the denial of summary judgment, even though they asked me to sign up for something different. I said go to trial. They decided not to go to trial.
Let's
Now, what
assume
I would
for-
like-
I'm sorry, sir, just assume for a
Justice
moment.
Hagan?
I'm sorry, just assume for a moment that the so-ordered stip can constitute a judicial determination for the purposes of FAPA. Would an acknowledgement that the defendant lacks standing or that there's a triable issue of fact as to standing be synonymous with an invalid acceleration of the debt?
If under freedom, I can't think, Freedom Mortgage v. Engel, under Engel, that would probably be the case unless we had a separate document accelerating the loan. And that actually is the discussion I wanted to have with the court, because there is such a document in this case. But the reality here is that the stipulation could in no way be deciphered or interpreted to mean that it was a judicial determination, and Justice Gonzalez herself said it was not, okay? And she wrote that decision, and she was the presiding judge in the foreclosure action. So the decision here is in the record on page 4, I believe. What I just want to call this a court's attention to is that your decision in Genovese, certainly, which we cite in our brief, was correct, that this court has followed that decision with 3 additional decisions holding FAPA applicable in case just like this, and those decisions were rendered after our brief was submitted on October 30th, and they are Bayview Loan Servicing v. Delal, Bank of New York v. Del Rio, and last Friday, 630 6A LLC v. UA Bank and Trust NA. And there are 3 judges on this panel who have been involved in those decisions. So I don't think I need to discuss FAPA. I will only say that the Second Department recently held in 97 Lyman Avenue v. LLC, 97 Lyman Avenue LLC v. MTGLQ Investors was decided on 12/24/24, and it follows your decision in Genovese. And U.S. Bank NAV Lynch was decided by the Third Department on October 24th, and it follows the Genovese decision and the others as well. Consequently, what I want to discuss today is the effect of the 2010 letter, independent of FAPA, okay? And that's our point 2. And the plain reading of that 2010 letter is that it was a demand for full payment. And I'm going to simply skip, unless you want to know exactly where it's located. It's at page 156 in the letter, and it was Exhibit H, I believe, to our complaint.
What was unequivocal about the,
Michael?
yes, what was unequivocal about the language making a demand for payment in that letter?
Sorry, I'm not.
What words were used in the letter that you deem make it unequivocal that it was a demand for
Well,
payment, other than
because-
something that was informational?
Because the letter follows the note and mortgage. And the note and mortgage is something that most courts forget to look at in these cases. And apparently there's no prior decision involving analysis of the note and mortgage. So the
But
note.
the question was, what language in the letter?
I'm going to get to that.
Please do,
It
because
follows-
you have 10 seconds.
Okay, well, probably can't do it in 6 seconds. There was an earlier letter giving 30 days notice in this case. And that letter is in, well, if I have 6 seconds, I won't give you the location, but it's in the record.
Okay.
And it's in our brief. And that letter is pursuant to the terms of the note, which appears at record page 66. And the terms of the note require a 2-pronged notification of a default and demand for payment in full. The first gives the borrower 30 days additional. And that, by the way, is the same letter that was said not to demand full payment in Vargas, which is part of the Engel case.
So I, just because you're out of time, I want to make sure I understand your argument. Are you saying that the plaintiffs here neglected to fulfill that 2-prong notification?
Did not.
Did
They
not.
Did not neglect.
Okay.
They fulfilled the 2-prong notification, but it was the plaintiff servicer who served the first notice. Then the second notice, it demands a full amount of money. It does not give the borrower the opportunity to pay a monthly sum in lieu, and and continue making monthly payments, which is a key aspect of this.
Thank you.
The letter-
You're out of time. Thank you so much. We have your brief and your arguments.
Thank
Counsel,
you,
you
Judge
have a minute.
Masonet.
Thank you.
For brevity, unless the court has specific questions, I do address the 2010 letter in my briefing, specifically that the Vargas portion of Freedom Mortgage Corp. versus Engel specifically holds that that letter would not constitute an acceleration of the debt. And also the additional 2 letters that is referenced by counsel, those letters were not included in the complaint as a triggering accelerated event.
Okay.
He is seeking to amend his pleadings via brief, which cannot be done. And unless the court has further questions.
Thank you so much.
Thank you, Your Honor.
Gaon Wellness versus GI. You may proceed, sir.
May it please the court, David Cohen, the Basel Law Group for Appellant Gaon Wellness. This appeal is a little or somewhat unusual because the motion court granted summary judgment on grounds that were not requested or argued by the moving party. This was a case where the court entered summary judgment granting summary judgment on the first and second causes of action, breach of contract with the covenant not to compete, and also regarding confidential information. What the motion court held that because there was evidence in the record that the respondent was at the time the contract was entered into, that she was in fact engaging in activities that would have violated the contract. The motion court found that there was no meeting of the minds. Motion court did not cite to any authority, and also the motion court did not take into account the affidavit of the owner of Appellant, who said that he was aware in the past that the respondent had violated this type of order or clause, but he spoke with her and she agreed that she wouldn't engage in any competition, and as a result, that raises tribal issues of fact as to whether that the contract could be entered into. And then the court also said that, looking at the contract itself, that there was no meeting of the minds, and that was because the contract talks about acupuncture or oriental medicine, and respondent is a physical therapist. However, if you look at Section 9 of the contract, which is on page 75 of the record, it identifies the respondent as J. Kim PT, which is a common initial for physical therapy. And also in the covenant not to compete, which is Section 6, it's the contract says the contract doesn't specifically require or the respondent to engage in acupuncture services to violate the non-compete, but if she becomes involved in any activities competitive with the activities of the practice, and the practice did have a physical therapy component to it. Now, so that's the and then one of the other very important aspects of this is the signature page. Respondent says in her affidavit that she didn't see the that she wasn't given the entire contract, just the signature page. But she does admit she signed it. And on the other hand, appellant in his affidavit says that he gave the entire document to the respondent, saw the respondent viewing it, had no questions, and signed it. Now, one thing that's very interesting, if you look at that page, the top of the page, it has language saying the employee and the employer agree that all of the terms above are binding on the parties. And she claims that she never saw that, but at the same time, respondent owns 2 physical therapy clinics and is a sophisticated business person. Taking all these facts into light, most favorable to the appellant, there are,
Issues of fact.
yes, Your Honor.
All right, you'll have time on rebuttal. And you had 12 seconds left, by the way, so I wasn't cutting you off. Okay.
May it please the court? My name
Yes.
is Deborah Bryant, representing the respondent in this case. There were no questions of fact, genuine questions of fact that should have caused a denial of the summary judgment motion, while there might be a he say, she says regarding this.
Well, that is the quintessential question of fact. He said, she said means there are 2 different versions.
Absolutely.
And the court, in a summary judgment motion, is not supposed to make credibility determinations.
Absolutely.
So tell me how this decision does not violate that.
Okay, well, in every case, you're going to have someone says one thing against another person. However, what you have to look at is the undisputed facts. Are the undisputed facts sufficient and go against the weight of evidence that it would be ridiculous to find anything other than what you these undisputed facts? And those undisputed facts are, yes, she signed the agreement. She never intended to be bound to a covenant not to.
Except we know that the law in this state is that you are bound by the terms of an agreement that you sign, whether you read it or not. So
Absolutely.
tell me how she gets around that.
She gets around that because there's plenty of cases where people sign documents and yet they're not bound to the agreement because the
Tell
agreement.
me how she is
because
not
the-
bound.
Yes, ma'am. The agreement is unenforceable as a matter of law based on the
Why?
undisputed facts. The undisputed facts are the agreement itself says that she's an acupuncturist. If you look, what did she violate in this agreement? Assuming this agreement is
Let me see.
it says,
What the allegations here are that several of the plaintiff's clients no longer go to plaintiff but go to defendant, right? And that would seem to be in violation of the covenant to not compete. No?
no, the covenant not to compete on section 6 actually says you shall not perform acupuncture services.
I get that. But she wasn't hired to perform acupuncture
She was never hired to
service. She was hired to perform PT,
Your
correct?
Honor, absolutely, that's not,
Okay,
that's not
and
correct.
that's
That's not
what-
correct, Your Honor. I'm sorry.
You keep talking, please. Go ahead.
It's not correct because, as she puts forward, she helped create the company. She was a founding
She
member.
helped create what company?
The plaintiff, she was
No.
a member.
She was brought into that company.
No, she started,
So she may, counsel, if you'd like to have the floor, I will stop talking and I will let you say whatever you want. But if you're interested in what we are concerned about, then perhaps it would behoove you to answer our questions and wait to see what we are concerned about.
absolutely.
But you can chart your own course.
Absolutely. What question would you like me to answer?
No, go ahead, because I've asked you questions and you've answered what you want to say, so please proceed.
Your Honor, it's undisputed, it's undisputed that she was a founding member of this
Counsel,
company.
it sounds like you're trying to have the court look at extrinsic evidence, evidence outside of the contract, but the law says we're only permitted to do that if the contract is ambiguous, and there's nothing ambiguous about this contract.
Well, the lower court found that it was because it talks about acupuncture. Her name is not even on
Also,
the contract.
the mere fact of the service being acupuncture versus physical therapy is the ambiguity for you?
Well, actually, throughout the entire document, it talks about acupuncture. And other people have been hired as an acupuncture, which she has signed documents before. This is not the document concerning her. Her name appears once in the entire document in section on like the 7th page of the document. And on that 7th page, it's regarding contacting her for notices. She was a member at the time.
But she signed the document at
Yeah,
the
but there's
end.
plenty of cases where people sign contracts and they're not bound by it because the contract itself is found unenforceable, as the lower court found in the Jessen Electric case. In this particular, what happened here is this agreement, she was a founding member before this agreement was given to her. She didn't come on board because of this employment agreement. She was a founding member. In 2018,
And
this
again,
company-
these facts that you're bringing forward, we have to look outside of the contract to determine that the facts that you're saying are true.
yes, you would, when there's an ambiguity in a written
But
contract.
there is no ambiguity.
Well,
The
that's.
fact that there's no question that there's an error, okay? That it seems to me that the plaintiff here used some standard contract that they had and didn't scratch out acupuncturists for physical therapists. That aside, we know that the facts on the ground are that the only service your client provided was physical therapy. So we knew that what they were talking about was physical therapy, not acupuncture, because your client is not licensed to provide acupuncture
Absolutely.
services, right?
Your Honor, there's another important point. The agreement also says that she's going to be paid, if you want to say there was a contract, okay, so when the contract existed, but plaintiff breached that contract, plaintiff, and this was also brought up with the court below, it's in the briefs, and all the evidence shows this. It's undisputed, she was never paid $30 an hour as this contract says she would be paid, and plaintiff can never prove, never came forward showing that he paid her $30 an hour for physical therapy treatment.
Thank you.
And there's plenty of other reasons why this contract,
But there were payments made to her.
as a member of the company, and it
Not-
says
it's not cle-
K1.
It's not clear that it says as a member. It's not, it doesn't say in the memo of the checks for profit. It doesn't
It says
say that.
K1, Schedule K1.
And while, just bear with me, I understand the record. When you pay someone $30 an hour, you usually give them a check once a week or biweekly. That's how it worked. He wasn't paying her, and finally, when she complained, and as part of her position, she says, "Oh, I signed this, so I hope we'll get money." I understand your client's position here, but she signed. It says employer-employee agreement. That's what it says on top. Notwithstanding, she's an arguable 1% member, arguable, and she was paid in lump sum checks. That's in the record. So you want to say maybe it's profit versus the $30 an hour? Well, that would make it a triable issue.
Well, the articles of incorporation that were filed for the creation of this company, when she helped create the company, said that she was a member and that she was the licensed physical therapy member, founder of the company.
How do we
And
even get to articles of incorporation when we have a contract right in front of us?
Because the payments that she was receiving were her distributions as a member, not as an employee. You have to have a W-2 form.
All right,
when you're.
thank
and she
you.
never
We
got
are
one.
way out of time and way off the issue on this appeal. Thank you so much. You may proceed. You have 1 minute.
Thank you, Your Honor.
Counsel, how do you respond to your adversary's claim that the contract is ambiguous because it mentions services for acupuncture versus physical therapy?
Which clearly is wrong.
Well, yeah, that's true. Well, first of all, my client said in his affidavit that he spoke to the respondent and they agreed that it was an error. Second, as I mentioned earlier, she's identified as PT, physical therapist.
And it said services for acupuncture and oriental medicine, right?
Well, Gaon has acupuncture, physical therapy, and chiropractic. The other,
Counsel, physical therapy is not oriental medicine.
no, that is right.
Okay.
Yes.
So just concede what is obvious.
Yes, Your
There
Honor.
was an error.
Yes, there was. It was an error.
Okay.
There was.
I'm going to give you 30 seconds since I interrupted you.
Okay, thank you. Counsel said that Ms. Kim's name was on the contract only once, on the contract twice, in the notice provision, and then her signature, and then, as far as this idea that she's a founder of the company, she owned 1% of the company. There's an affidavit from from one of the lawyers that.
Counsel,
Counsel
can you
does-
be, I'm sorry,
Yeah.
may I?
Go
ask one
ahead,
more question?
please.
Can you be a member and an employee?
Yes, you can.
Okay.
Thank you.
Thank you. That's it. Thank you. Mangial versus SR Taxi Corp. You may proceed, sir.
May it please the court, Your Honor, my name is Stephen Toner. I represent the defendant appellate in this case, and I will just try and hit, there's a number of issues in this case. I will just go across them and then respond to any questions you might have to focus my answers. This appeal is based upon two main requests. Number one, to dismiss the jury's verdict in favor of the plaintiff based upon the failure of the plaintiff was to establish a threshold under 5102 of the insurance law, that there was a lack of objective medical evidence sufficient.
I think that in light of the record here and the devastating consequences to this plaintiff, you would probably be better served on other arguments.
Okay.
Now, if you want to argue whether on the issue of inconsistent verdicts in light of the findings, I think that is a more fruitful use of your time.
Absolutely.
Okay.
Absolutely, Your Honor. And as pointed out in my brief, the jury had a finding of consequential limitation of use of body member or functions, but the category here that case law makes it clear that significant limitation of use may or may not be permanent, but a permanent consequential limitation must, by definition, be significant in order for the plaintiff to satisfy this serious injury.
Now, let me ask you something. Here, the plaintiff complained about a great many things, right?
Correct.
And so how can we discern, based on the jury's verdict and the questions posed to them on the verdict sheet, whether they found no significant limitation as to a particular complaint, but found a permanent consequential limitation as to another part of her complaints? How do we know, based on the queries that were put to the jury?
Because the evidence at the time of trial was primarily, if not exclusively, subjective complaints made by the plaintiff.
They always are. They always are, because there is no test that can measure pain, right? So it's always subjective complaints of pain. I can't do this, I can't do that, I hurt, right? So it's always that. But here, we know that in motor vehicle accident cases, our case law says that if the jury can find one injury, they can award damages on even those injuries that might have been dismissed on summary judgment, right?
Right.
So again, how can I, as the court now, determine, based on the record I have, that the jury's determination was somehow based on the same complaints?
Again, Your Honor, there's an 8-year gap in the treatment. All of her complaints that she made at trial were the same complaints she had made in years prior based upon an autoimmune disorder that she had been treated for.
But none of which had her in the disabled state requiring the ingestion of Vicodin around the clock. So prior to this accident, she had this autoimmune disease for some time, right?
Yes.
And yet she was able to function. She had no problem in being a very highly skilled, specialized attorney, right? And she has this accident, and now she is in so much pain that she has to take medication that numbs most people to sleep all day.
Well, Your Honor, I'd like to use the remainder of my time to address the disclosure of a $10 million lost earnings claim that was done 2 weeks prior to trial, despite 17 years.
Yeah, but the jury ultimately awarded what, about 40% of that?
Just under 1 million.
So again, you don't have that kind of exposure. I mean, the bottom line is you sought an in limine ruling, and that's why you're up on appeal, because the economist got to say what the economist got to say, correct?
Well, both, oh, sorry.
Well, among other things, plus the expert medical witness testimony and looking at certain later MRIs. But the bottom line, the economist's findings or opinions weren't even based on the very tax returns that you claim you never got. So there's no prejudice there.
Well, there is, because the disclosure of that expert saying whether it's $1 million or $10 million in violation of 2133 or 3122A of the CPLR, that had to have been disclosed 30 days prior to trial.
Okay, did you seek a continuance so that you could get a contrary opinion, which you clearly could have asked for and probably gotten? So did you request it?
I moved for preclusion of that.
Right, but my question was, did you seek additional time? Because the remedy to late disclosure is preclusion, or judge, give me time so that I can at least meet the other expert head on, right? So did you ask for that?
I did not ask for that because there was a firm trial date by Judge Getz at that point. But
you don't know, unless you ask in light of the situation, the judge could have said, you know, you're right. You certainly should have a chance to have your own expert, and we'll have to postpone the trial. Postponements in our courts happen every day.
I'm very familiar with it.
Yes,
Your Honor.
I'm
It's
sure
not
you are.
Not a rare occasion that this
Right.
happens. And I will say that routinely, when this is brought up, the court will say to the proponent of that evidence, you've got two choices. Go to trial without it, or we're going to adjourn the trial for a month or two to give the objecting
Give you a
side,
chance, right.
to the opportunity to get an expert or do a deposition of their expert
So you
or whatever.
selected to not delay and go forward.
Well, it wasn't a matter of my selecting. I will have to, I'm recalling the conversations that probably were not on the record, so I can't argue that.
Right.
But the last thing, because I am out of time here.
Right.
I do want to also mention that Dr. Engler's report was soft tissue. It was vague. His supplemental 3101 disclosure that was served 1 week prior to trial or 2 weeks prior to trial while we're coming up for jury selection. This case had been on in January before.
But that happens all the time.
But-
So I get it.
But the report of Dr. Engler and then him getting on the stand and saying that she needs immediate surgery because she's in risk of quadriplegia was never stated in any type of a bill of particulars, was never stated anywhere.
You'll be able to finish hammering this point home on rebuttal, okay? All right.
Thank you, Your Honor.
Counsel.
Thank you, Your Honors, and good afternoon. My name is Jay Breakstone. I represent Ms. Mongeau, the respondent. Well, Your Honors said it in your questioning. And what really concerns me here is that what counsel is trying to do is get significant limitation as a lesser included. My background is in criminal defense many, many years ago. We used to call a lesser included offense. And that's not the case here. They can be two separate things, especially when you're dealing with possibly two separate injuries. There's
And
no
what
way-
are those separate injuries?
Well, I wasn't the jury, so I don't know. But the fact of the matter is that the jury made its finding not relating one to the other. And there was no questioning. There were no injuries that were separated out in questions to the jury, which could have been done, and I've seen done on cases on trial. That was not done here. And there's, yes, go on.
Would you agree, assuming arguendo, your friend raised the valid issue of an inconsistent verdict, which is what he's trying to do here? That wasn't preserved. In other words, that wasn't put forward before the court below while the jury was present to arguably have them revisit these issues, correct?
If I had to go to that level, I'd say yes, but there's nothing inconsistent
But
about
they
the
didn't do it,
verdicts.
which means that you can't raise it.
There's nothing inconsistent about these verdicts, and you're right, Your Honor. the time to raise it would have been at the time to raise it,
Before the jury was discharged.
before they're out of the box, Your Honor.
Right.
If there was a question at that level and at that case. With regard to the sort of backwards way we've entered into this mitigation case question, I think Your Honor raised it very well. There's a $10 million request and you get $990,000. That in itself is a concept of mitigation. And it's somewhat offensive to me that somebody who's a patent lawyer gets into this position and we're starting to, and it sounds like nickel and dime, but we're not nickel and diming it because the loss of income is severe to somebody who's a patent attorney. That will nickel and diming this question in the case of excessiveness. There's nothing to indicate there's any excessiveness here. There are no cases cited that it's excessive. And I think that's the obligation. If you've got an argument, you've got to make it in front of this bench. And as Your Honor said, if you have some arguments, you have to raise them in front of the trial bench, or you can't raise them in front of this bench. I think that's the situation we have here.
Now, counsel, I know that counsel is challenging the supplemental report from 2022, but that supplemental report just really focused on additional testimony regarding 2011 and 2013 MRIs, correct?
It's not you're correct, Your Honor.
Right.
It's not inconsistent with the factual information.
Right.
One wants to say
Because in fact, Dr. I believe it was Lenzo, he had mentioned those same MRIs in his report, right? And that was like sometime in 2018.
And then if you have a problem, as Your Honor's know on trial, if you have a problem like this, you turn to the judge and you say, Your Honor, I have no time. I just got this. How many times have we done this as trial judges? I've got this, and the judge will say, take 2 days, take 3 days, take the afternoon. But if you don't ask and all you want is the sort of Damocles of a mistrial after a case is pending for 17 years, that's going to be a really rough argument to make, and maybe you decide not to make it, which is maybe what happened here. Thank you, Your Honor.
Thank you. Okay, you have a minute.
Yes, Your Honor. I'll just address a couple of points. Factually, the plaintiff, as a patent lawyer, in the time that she was employed following this incident, this car accident, continued to increase her salary year to year until 2006, when she said that she wasn't going to work anymore. She testified that that she never bothered looking for a job again, despite Dr. Engler's testifying that she could have been gainfully employed. So I just wanted to address that. And I don't understand what the two separate injuries that are being referred to here. The plaintiff went to her PCP the day afterwards, making complaints of neck and back and shoulder pain. And it wasn't for 6 months or so that she ever got her first MRI. And the MRIs in this case, when they were done consistent when this case was coming up for trial. There was no treatment involved during this time period or as a result of those MRIs that Dr. Engler, who's hired as a trial expert, that opined on that she underwent some kind of treatment or additional need for treatment as a result of those MRIs.
Thank you. Brown versus 39 Spring Street LLC. You may proceed.
Good afternoon, Your Honors. Bernard DeRazio for the plaintiff, Laura Brown. This case revolves around the interpretation of a promissory note, and it has a very unusual provision in it. It doesn't have a payment date. It doesn't have a fixed payment date. The note was drafted by the defendants in connection with the sale of a very valuable real estate asset in Soho. The Browns, George Brown, Laura's ex-husband now, and Laura had lived in that unit for a period of time as a marital home. It was marital asset. They were going through a divorce. George wanted to sell it. Laura consented to the sale. There was a tacit agreement to share. There was an agreement to share the proceeds 50-50. Laura was instructed to show up at the closing, She was not given any documents. She did not have her matrimonial counselor or any other counsel there. The defendants, there was a purchaser of the LLC, LLC run
And
by,
unbeknownst to her, her husband was one of the purchasers, but she didn't know that when she signed the agreement.
we didn't find that out unless we clawed for it in discovery in this case. And then after they redacted documents to hide it from us, we got it through non-party subpoenas.
And during the closing of the sale of a very lucrative piece of property, it wasn't until the closing that this woman, who was not represented by counsel, who was relying on her husband's, soon-to-be ex-husband's good word, that she learns that there's a provision that she's asked to sign without counsel that delays her ability to be fully paid until God knows when.
God knows when is the right term, exactly. It says ambiguous term, 90 days after a long-term tenant begins paying rent.
And is there anything in that contract that was drafted by the two buyers,
It could
right,
only be
that tells us what a long-term tenant is?
not a word
Not one word.
or nothing else.
Counsel, how do we deal with their affidavit that in the commercial real estate space that long-term means 10 years?
There is no such affidavit.
Okay.
Okay, what there are a statement, one sentence in Gomez's affidavit where he says, I believe a long-term tenant in New York means 10 years or more.
And
Oh, so
what
that's a-
expertise does he
Unknown.
allude to in this affidavit that this court should put any credence in what he thinks and believes?
None. And
So
now there's an-
counsel, there was an affidavit, it's just not an affidavit that meets the standard for,
It's not evidentiary material.
Okay.
There's no firsthand knowledge. It's
So when there's credibility involved here, then the court is, as a matter of law, in your view, committed error in interpreting it in favor of the buyers.
If we're looking at the note, it's an ambiguous term. It's very, very ambiguous.
You need a trial
Right.
to determine the intent of the parties.
No, we do respectfully no. The Court of Appeals has made it clear that where it's ambiguous, and there's no question it is, the parties may submit extrinsic evidence to clarify the ambiguity. Here, there was no such evidence.
The extrinsic evidence was self-serving affidavits.
Exactly. Not
That's
only by
it. There was no
Gomez-
evidence.
Right, no evidence. Not only Gomez, but George.
I said so that must be the case.
And George himself, who now we know is on both sides of the case, he's a photographer, for God's sakes, said, I think it means.
Ain't nothing wrong with photographers,
like
of course.
photographers.
Okay.
But he's certainly no expert about what that term means. So there's no evidence. So in that case, and I point out the Court of Appeals 2 weeks ago in the Dobrish case, which I will upload later today, had a contra proferentum case that just came down, right? And in Dobrish, we had involved an insurance contract, and the parties there did submit competent extrinsic evidence. Both sides did, including expert opinions and other materials going to the interpretation of an insurance contract term. And there the court said, you're going to have to go to trial to resolve it because it's real evidence and it doesn't conclusively resolve it. Here, it doesn't, we don't have that. In fact,
how
the Court of
about this document that they submitted, which was some sort of New York City open data spreadsheet? It was like,
Yes, they submitted a website page.
Right, I know.
Right. Well, what it is, we're not sure. But it's not admissible evidence, right? It's not authenticated. It's hearsay. We pointed out in our briefing on it that it's parties can provide upload information to the city. It doesn't state what a long-term lease is. At most, what it says is that the average lease term was 10 years. It doesn't
So
say.
you're
what-
saying that we can, in invoking contra proferentum, that we can interpret give the contract a meaning, the phrase long-term tenant a meaning as a matter of law in your favor. What meaning would that be?
Well, what we would say is it's 7 years is long enough, right? So we're now 8
Counsel,
years.
but then your argument suffers the same ailment as your colleague, okay? There's no expert anything in this record to support either of those positions.
The rule is and Dobrush
Well,
points this out.
No,
where there's
I'm sorry.
There is no
You-
evidence, Judge.
Exactly. So how can we determine something as a matter of law?
In Sutton, which is cited in our brief, Court of Appeals, 1982, in Dobrush, 2 weeks ago, Court of Appeals, they said that where there is no extrinsic evidence, it becomes an issue of law for the court. That's what it is. That's what it says. And there's also another case. cited in
So the
Dobrush.
court now becomes experts in real estate? Where there's no evidence in the record?
I'm going to read what it says.
No, I don't need you to read what it says. I can read it for myself. Thank you very much. And with all due respect, please have a seat. You'll have time on rebuttal.
Thank you.
Gregory Burns for respondents.
So tell me how your client's self-serving affidavits carry the day here.
Well, Your Honor, or judges, this is a contract. The operative agreement here is the contract of sale between George Brown and the respondent, or really 39 Spring Holdings LLC. It is not the note with Ms. Laura Brown. She is the beneficiary of.
She is part owner of this property.
No, she is not. At no
Really?
point was she ever an owner of this property. I believe counsel has admitted that in their papers as well. So the agreement was between.
She possesses that promissory note regarding monies due to her based upon the sale of this property.
And the property interest that her ex-husband obviously admitted she had.
Well, the issue with the ex-husband is not relevant in this case.
Really?
No, we actually
you think not.
requested discovery in this case, and we have
You
not seen
think
this.
not? You think that her ex-husband is not an issue in this case?
No, Your Honor.
He brings her to a table, asks her to sign a contract that she hasn't seen before that day, that limits her recovery to some day, God knows when, and you don't think he has stake in this issue?
No,
You
Your-
are so mistaken, counsel.
Your Honor, may I
You absolutely can.
Mr. Brown could have had Mr. Gomez issue that note to anybody, anywhere. It was not subject to the agreement where the disbursements go. They will just be dispersed where Mr. Brown says the disbursements to go. The note was negotiated by Mr. Brown, his counsel, and my client. I don't believe our client's counsel at the time was involved with drafting the note. Here are no emails that were submitted in.
They're partners. What are you talking about?
Well,
At the end of the day, they are partners. And all your talk doesn't change that.
no, Your Honor, and it.
No, you're right, it doesn't. They're 50% owners in the property that they negotiated right out from under her.
So this is an issue for her to deal with Mr. Brown directly, not with the entities that are involved here. And I believe counsel filed a lawsuit earlier this month dealing with that issue. That is between them. That is not with the entities here. The note that was entered into was negotiated by Mr. Brown and Mr. Gomez. The meeting of the minds between them is what came to the terms there. In support of that, we have
They
submitted.
needed her signature on that, right?
We did not need her signature on that.
But they
Notes are
put
all-
it in front of her.
Yes, I don't know why that was done, but notes
It,
are
it didn't
often.
have anything to do with the divorce and dividing marital property?
Yeah.
We have not been providing anything in the record based on this. Our discovery responses were requested the divorce documentation, provided 3
So,
pages worth.
Even if we go back to, and we accept what you're saying, and we go back to what was in their minds at the time that they were signing off on this note, where do we have any evidence that at that time, in their mind, long-term meant 10 years? What evidence do we have to that?
We only have them. They are the only 2 people, and they are the people with the
They're
meeting of the minds. and
self-serving affidavits?
They're in agreement with each other. They're both in agreement. These are the
I'm
people.
shocked. They're in agreement with each
Yeah,
other?
imagine that.
But who could question the people of there is no dispute that they were the ones that negotiated the entire deal.
That's
That
not
George
the
Brown-
issue. You keep on saying that like somehow that saves you. That is not the issue.
The consideration from the
That
transaction.
is not the issue.
Your Honor, and I would.
Because what's in the promissory note is ambiguous, and we have to look to some sort of extrinsic evidence, it has to be something of value, not just what we think were in their minds or what they've come together now that it makes sense for them to say. And did you provide anything that gives us a sense of that?
Yes, we provided New York City open data, which is collected through the real property income and expense statements required to be submitted to the city through local law 157.
How is that not hearsay? And why should this court rely on a photocopied page of an internet?
Well, Your Honor, we link directly to the data, which is posted for everybody to see. This is open data provided by the city.
Because
and the
things
only
on the
collection
internet are all accurate, right?
through New York, this is what New York City collects through the law that commercial tenant owners are supposed to pay. And this is only retail data throughout the state. I'm not aware of any other collection of data out there.
But what about the online articles? And that deals with office space. How is that even related when this is a residential property? Because that was also done as well. Online articles about office space.
Those are submitted as further support, but the primary support.
How?
It is showing the length of leases. They speak about the length of leases, what long-term leases are. I would submit that they are less relevant to this to the issue here, and that the open data is specifically on point for what is collected and the most accurate and knowledgeable.
And do
That
I
data
have
is
an
submitted-
expert affidavit in this record that tells me that this site is the end-all, be-all of real estate know-how?
No, Your Honor, but you do have my affirmation on how we collected the data, where it comes from, the law that it's required to be collected under, and how people are forced to swear that these are true and accurate statements submitted to the city. It's about between 60 and 70,000 leases that they have data on, that they provide information.
And how many thousands of leases do you think exist in New York City? So what percentage is 60
For
or
retail spaces?
70,000? Yes,
I don't know. My guess is probably closer to about 70,000.
but we don't know because we don't have an expert affidavit that tells us, right? Right. Thank you. You have 1 minute.
Judge, on the issue of whether there's an issue of fact on this record, I think we are bound by the Court of Appeals on this. And in a situation where there is no admissible extrinsic evidence, the courts have a long tradition that the judge is the person best to decide. You ask a good question, how is he supposed to decide? And the reality is, since there is nothing, he has to figure it out using his common sense and experience. So the issue is whether a 7-year lease is long-term lease or not. And that's what it comes down to. They say it's 10, that's made up in thin air. We don't know that. I'm not making it up that it's 7. What I'm saying is,
7 sounds just as much out of thin air as 10.
I'm saying,
I'm sorry.
but I'm just saying it's long enough.
Well,
I'm not saying
7
it's
sounds
7's the bar.
convenient because that's the current lease that's there now.
Well,
That would
that's the
trigger
issue.
payment.
That's the issue that we face.
But I think you're missing, this is my understanding of it, and I hear what you're saying, but they did proffer extrinsic evidence. Just listen, you don't have to like it. You can think it has very little weight, but this is summary judgment. It's issue finding, not issue determination, if there's an issue. They proffered 2 affidavits that you characterize as self-serving. That's fair. Just let me finish. And they said they believe it was 10 years. Okay, that's a credibility question. And the Court of Appeal that you've been quoting all day long here basically said that when you're confronted with extrinsic evidence, such as what's being presented here, that determination can't be made as a matter of law. It has to be done by a fact finder. And that's pretty much well settled.
And on that note, I thank you both gentlemen. Next case. People versus Fabian Koch. You may proceed.
Thank you, Your Honor. May it please the court. My name is Joel Rudin, and I represent the appellant Fabian Koch. I'd like to begin by addressing the 2 pieces of evidence that the people contend established Mr. Koch's guilty intent beyond a reasonable doubt. The first is the DNA evidence. The DNA evidence, according to their expert, showed that there were about 6 or 7 cells of DNA found on the slide of the murder weapon, of which 2 individuals, in addition to Mr. Koch, were equal contributors. Maybe two of his cells were on that slide. The people's expert testified that it's impossible to tell when any of that DNA was deposited on the gun, and furthermore, that it's impossible to tell.
I just want to be clear. Was the Was the conclusions of those exams that the defendant was could not be excluded as a potential contributor, or was 163 billion times likely to be one of the contributors? Because to me, there's a difference.
Well, I think the conclusion's both. And we're not disputing, for the sake of this appeal, that the people are entitled to all reasonable inferences from the primary facts. The people established, giving them the benefit of the doubt, that my client's DNA was almost certainly on the slide of the gun. That's not the point for purposes of the sufficiency argument.
Okay.
The issue is whether or not that DNA was deposited on the gun in a manner from which a fact finder could reasonably infer guilt beyond a reasonable doubt. The answer is no. Their expert acknowledged that there were two other equal contributors, that it's impossible to say when any of the DNA got on the gun, and furthermore, that it's impossible to discount that the DNA got on the gun through secondary transference. Someone else in the car.
Just so I understand you, you are, with regards to the DNA, arguing about transference versus the sufficiency of the DNA being enough for this circumstantial case.
Yes. That if this is their expert. Their expert did not even testify that direct touching of the gun by Mr. Koch was any more likely than secondary transference. We're talking about two cells. And he must very likely shook
what the expert said, and this is Ms. Hardy, what she basically testified to is that she couldn't exclude his DNA from being a contributor.
Yes.
And if she had additional sample, like a known sample, that further testing could have been done to make it clear whether in fact his DNA was on that slide.
Yes, but I'm giving them the benefit of the doubt. I'm assuming.
But I need you to focus, please. Yeah. I need you to focus on my colleague's question, okay?
So instead of giving them the benefit of the doubt, why don't you just set forth your argument as to why you believe what we have here is not legally sufficient and why this verdict was against the weight of the evidence?
I guess I'm not being very articulate, but that's what I'm trying to do. Even if you assume that the two cells of Fabian Koch's DNA on the slide of the gun, their expert acknowledges that first, given that there are two other contributors, we don't even know the sequence of when the DNA was placed there. Second, we don't know when it got there. It could have been weeks or months before. Mr. Koch could have, assuming he handled the gun at all, could have been weeks before. And third, that DNA could have gotten there through secondary transference. Mr. Koch was with these people earlier that night. There's no question about that. He could have shaken the hand of one of them.
Was that proven beyond a reasonable doubt? And this is from your argument,
Yes.
not from giving the people any benefit of the doubt, right? Because what we have are a bunch of video surveillance and arguments in the record that still photographs match Mr. Koch.
Yes, and again, I'm giving them the benefit of that inference because they won the jury verdict. So assuming that Mr. Koch was in the videos from 3 hours before at the liquor store and 98 minutes before at the Sunoco station, he was in their presence. He could have shaken their hands. He could have touched something in the vehicle that one of them touched, and then that person touched the gun. We're not talking about a lot of DNA. We're talking about two cells, and their expert did not provide any testimony that it was more likely that Fabian Koch touched the gun, let alone at the time of the crime, than it got there through secondary transference. So how could a jury possibly decide that it got there in a guilty manner, evincing his guilty intent? There's absolutely no way. And so what's the other evidence?
Sir, there's going to be some redundancy here, but I just want to be very clear. Cast aside your legal sufficiency argument for a moment. Where your against the weight of the evidence advocate had, we're the 13th juror. Give us the syllogism of this verdict was against the weight of the evidence argument.
And grounded in the fact that this is a circumstantial case, right? Because we know from recent Court of Appeals decision that the analysis is a little different when we're talking about a circumstantial case.
Yes, you have to be able to exclude beyond a reasonable doubt reasonable hypotheses of innocence. And you cannot do that here because the DNA evidence is completely inconclusive as to how it got there and when it got there and when it got there and whether it got there in relation to the crimes. You cannot infer his guilty intent. And secondly, they rely on a 911 call, and they try to suggest to this court, like they did to the jury, that the 911 call was from someone who saw more than one person involved in the shooting, when in fact he said, somebody just shot my car, ma'am. Someone just what? Shot my car. Do you know who shot at your car? No, 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 no. How many shots fired? Probably 2. And you don't know who could have done this to you? No. It wasn't even near here. It wasn't like somebody was here trying to shoot us some. It must have come from somewhere. Do you know where it came from? Do you know which direction it was coming from? No, he didn't see the shooting. So how can they argue to the jury and mislead the jury the way they're arguing to this court that call somehow is proof that there was more than one individual who got out of the car and was involved in the shooting? The other evidence, the Sunoco video 98 minutes earlier, doesn't even prove that he was still there with these people. The liquor store video, he was shown to purchase 2 bottles of Moet champagne, was placed in a bag. When you look at the crime, that's Exhibit 100. If you look at the trial exhibits 55 to 63, there's 1 bottle of Moet still there. That doesn't give any indication of criminal intent, let alone that he was even there. So my answer to Your Honor's question is that I don't think the evidence is legally sufficient. We preserved the claim that it wasn't legally sufficient because of lack of proof of intent. They acknowledge that. That's our claim on appeal. But if you're going to do this on weight of the evidence, I don't see how this court can possibly exclude, beyond a reasonable doubt, innocent inferences from this extraordinarily ambiguous evidence. This case crosses far over the line from inference to speculation.
Thank you.
Thank you, Your Honor.
You'll have time on rebuttal.
May it please the court, Charles Wan for the respondent. Your Honor, the evidence here cannot be viewed in isolation in deciding whether there's a reason, what the reasonable hypotheses and inferences to be drawn from.
Outside of the DNA evidence and a lot of evidence from which the prosecution does leaps and bounds of conjecture, what are you resting on?
Well, Your Honor, the evidence, they all have to be viewed in together.
I understand that.
Well, counsel, actually, and you cited to the recent Court of Appeals case, right? And this is a circumstantial case. And the way in which this court, sitting as the 13th, so to speak, juror has to look at it is to look to see whether there's an inference of guilt is the only one that can fairly and reasonably be drawn from the facts. What evidence do you have in this trial where over 120-something exhibits were submitted to the jury that an inference of guilt is the only one that can reasonably be drawn from the facts here?
Well, I don't think there's a single evidence that does it, but they all have to be, when we look at them all together.
Yeah, you're weaving a chain of evidence, right? What was weaved here out of the over 120-something exhibits that were introduced at trial that paint the picture that the only inference that we have here is one of guilt?
Well, the surveillance videos show that the 3 defendants were together for hours.
Yes, but his presence alone is not enough, and you know that. So tell me, what evidence, as my colleague just asked you, what?
Just put it together for us. The DNA, and then what else, and then what else?
There's the DNA, there's the ballistics evidence, and also the medical testimony showing that most likely, as argued by the prosecutor's summation, there probably was 2 individuals there. And Sergeant Case's testimony that he saw 3 individuals in the vehicle. And so when all of this is, and the 911 call is at one point, the person in the 911 caller does say that they shot at my vehicle. I believe it was they shot at my windows. When all
the 911 caller says he. It's singular until the 911 caller repeats something that the 911 operator says to the caller. That's when it becomes they. So let's move away from that and just tell us about your other evidence.
Well, there's the DNA and also the fact that, as the prosecutor argued,
let's talk about the DNA. right? Because you keep going back to there's a DNA. And the summations of the prosecutor at trial hinged a lot on this scientific evidence. Let's talk about the scientific evidence here and the DNA. Was it that the Miss Hardy found that Mr. Koch could not be excluded, right, as a potential contributor to the mixture, correct?
Correct, Your Honor. And she also testified that it was, I believe, 162 billion times more probable that the three contributors to the DNA mixture was defendant and two others.
Right. And so let's talk about this forensic statistical probability. It was based on an algorithm, right?
Yes, Your Honor.
Which is no longer employed by DOCME, right? They don't use that testing anymore
Yes, Your Honor.
because it's unreliable.
I'm not sure. Well, I mean, it's not used anymore. No.
Because it's unreliable. You can concede that. You didn't know that at the time, but we know that now.
Yes,
And
Your
even
Honor,
if
it
it's
is no longer being
unreliable and it's not being used anymore, again, because it's a circumstantial case, you can pull together the other pieces of evidence that tie Mr. Cook to this shooting, if you have it.
Yes, Your Honor. The DNA is from the slide, which had to have been. It's not just that the DNA is from the handle or some other parts of the gun. It's from the slide, which the ballistics expert said has to be slid back and forward to load the gun, and also.
Yes, but they said, there was also evidence that they could not confirm whether it was a direct touch or a transfer. So everything you just said about it requires the slide is incorrect, because if a transfer could be the basis for this DNA, then that person didn't even touch the gun.
Well, there's also the evidence that the liquor bottles that the defendant purchased.
Oh, so now we're going to walk away from the gun, since I said what I said, and you're going to go to the liquor bottle. Deal with the gun.
Well, if you just look at the DNA just by itself, yes, we cannot deny that it might have been transference. But when you look at all the other evidence that shows,
And so
that
you were
defendant
talking
was
about
there-
the liquor bottle as the other evidence. Let's talk about the liquor bottles, right? Because the detective, Malarkey, never bothered to test the liquor bottles for fingerprints, never bothered to voucher the liquor bottles. What do we actually know about the liquor bottles that equate to some level of guilt that forms one of the chinks in your chain of circumstantial evidence?
Well, he didn't test them for fingerprint, but there were photos taken of the bottles in the car, and I believe it was argued by the prosecutor at the summation that the packaging is the same and the bottles were the same ones that were from the receipt recovered.
So
from the-
what?
So
what?
that gets us to perhaps, potentially, that Mr. Cook was present after he purchased, perhaps, potentially, these same looking liquor bottles. How does that take us to he also participated in committing the shooting?
And shared the intent to commit that shooting.
When the video,
That's the issue, right?
when the video of the shooting shows that the car pulls into a corner, and as the victim is approaching from the opposite side, and you can see the video of the car where it is, by the Sergeant Case's testimony, that the car is basically, the driver is basically taking his foot on and off the brakes, is being ready to drive off right away.
Yes, but we know that the driver was Jenkins. So what does that have to do with Mr. Coke?
I think when it all looked at,
And we know that Brown was sitting in the passenger seat. So what does that have to do with Mr. Coke?
well, when all the evidence is viewed together, it shows that defendant knew what the intent was. Everyone was.
How do we know that? Tell me what evidence is it, please. If there's evidence in the record I've missed, I want to know. So tell me what evidence is in the record that shows that somehow Mr. Coke knew that the intent of Jenkins and Brown was to shoot this woman down. Tell me what in the record, what page, where. In this record, I can look to support your theory.
There isn't a singular evidence, I'll admit, but when everything is looked at together, the fact that he knew, I mean, and then afterwards the cars, I mean, they drive away slowly, they're being followed by the police.
But sir, what is the strongest evidence that suggests that the defendant here was one of the perpetrators of this heinous act? We have strong evidence that there were multiple individuals, that there were 3 individuals. what is your strongest evidence that the defendant in this case was one of those three?
I'd argue it is the DNA, the fact that it is actually on the, I mean, it could have been transferred, but the fact that it is on the slide of the gun, which had to have been operated for the gun to be loaded and fired, and also the fact that the alcohol bottles, which the defendant is supposed to have, seen purchased, they're very expensive bottles. They're still in the car when it was abandoned. I think it shows the defendant was there. He should have,
Counsel, just so that we're clear, there was other evidence that was in this vehicle that was never tested, no forensic analysis ever done, right? Like 2 cell phones, right?
Yes, Your Honor.
And nothing was ever done with that. To find out who they belonged to, what potentially was in the cell phone, what messages, none of that was done, right?
No, Your Honor.
And the car was swabbed 16 times for DNA, right?
It was swabbed. I don't remember the number of times, but yes, it was checked for DNA.
16 different places it was swabbed, right, for DNA.
You're probably correct, Your Honor. I just don't remember the number, but it was checked.
Never given to OCME for an analysis.
I believe the only DNA test I'm aware of.
You had the DNA on the slide, so you didn't need anything else.
What about the other items in the car? A hat, a glove, anything done with those items as part of the investigation?
I don't believe there was any DNA test done on the other items, if I recall correctly.
If I'm not mistaken, was the defendant's fingerprints anywhere in the car?
I believe his fingerprints were recovered from the back seat of the car. if I recall correctly. I might be
His
wrong.
fingerprints were not.
Nope.
Yeah,
Just
I'm getting
Jenkins
mixed
and
up.
Brown.
In fact, there was a
Apologize.
third person fingerprints. I don't know the
On
name.
a cell
beginning
phone.
with an A or something, right?
Valderrama.
Right,
I apologize for the.
but not Mr. Koch, correct?
No, I guess all we have is his DNA on the.
So if he was in the car at the time, fingerprints would have been there.
I mean, if you can get fingerprints off a slide, you certainly should be able to get fingerprints from the defendant, from the door, from the handle, from something. He had to touch something in the car. He sat down in it, right? So that would have been a good way to add a little more evidence to your circumstantial case.
Not sure why we didn't recover any fingerprints, but the videos show that, they were together for hours beforehand.
Yeah, but the fact that you will agree with me that the fact that Mr. Koch was with these other defendants for hours is irrelevant to whether he was with them at the time of the shooting and participated, right? So if I'm with you at 6 o'clock and you commit a crime at 10 o'clock and I'm not with you, I'm not responsible for that, even though I was hanging out with you earlier. Can we agree on that?
Yeah, sure, but I think the fact that the liquor bottles the defendant bought shows that he was still there.
Well, he may have been there at one time.
One last question regarding the video surveillance you mentioned very quickly of the shooting. There's no actual surveillance of the actual shooting, right?
No, Your Honor, unfortunately.
There's only surveillance of a vehicle, right?
Yes, Your Honor.
And there's no way from that surveillance to be able to see who's inside of the vehicle, right?
No, Your Honor, it doesn't
And
show.
the evidence we have about who's inside of the vehicle comes from the first officer on the scene who says he believes that there were 3 males, right?
Yes, and he testified there were 3 males, and based on all the other
he testified that he believed that there were 3 males.
Yes, he said he believed he saw 3 individuals sitting in the car. That there was, I believe the testimony that he saw 2 in the front and 1 in the back.
Okay.
But just to go back to the video, because if I'm not mistaken, there were people going in and out of the vehicle, right?
Yes, but it wasn't caught in the video. All we see is I think the only thing you really see is just the left tail light of the vehicle. People leaving the car, unfortunately, is not caught on video.
And the defendant actually wasn't seen getting out of the vehicle, other people, but not the defendant.
No one is seen exiting the car.
Yeah.
Unfortunately, the video does not show. It just shows the getaway vehicle being ready to go away, but it does not. We have to admit that it does not show who left the car.
Thank you. Thank you so much. You have 2 minutes on rebuttal.
Thank you, Your Honor. I must say I appreciate the fact that this panel seems to know the case better than we do. I'd say, first of all, Arvi Valderrama is the individual whose fingerprints were found on one of the cell phones left behind in the car. There's nothing in the record to explain why he was not.
Was that cell phone found in the back of the car?
It's found in the front of the car.
Okay.
There's nothing in the record to explain why he was not made a defendant. With regard to the alcohol, the video shows that Mr. Koch, assuming that was Mr. Koch, and we're assuming that for the purpose of this appeal, purchased 2 bottles of Moet champagne, and they were placed in a black bag. When you look at the photographs of the car, you can see 1 bottle of Moet lying in plain view on the seat. You can see a bag on the floor. There's another bag, and that's the front seat. You can see another bag in the back seat. The police did not believe that the alcohol evidence had any significance to the case whatsoever. They didn't even voucher it, let alone test it for fingerprints or DNA, and it disappeared. There's also a bottle of Dom Perignon, and if you look at the videos, you don't see anybody in the liquor store buying a bottle of Dom Perignon. And I will submit that the only thing that this record establishes with respect to Mr. Koch is he had excellent taste in champagne. If the court has no other questions, I'll rest on the brief.
Thank you. All right. Owen Steele versus CUNY. You may proceed, counsel. You have 5 minutes.
Good afternoon, Your Honors. Please, the court. Kaufman Dalowich by Eric Ortman for Owen Steele. Your Honor, this case deals with a denial of an Article 78 to reverse a final administrative decision that denied 2 disputed claims, one of which was a change order related to additional costs related to steel costs, another of which related to temporary permanent handrail installations. If I can start with the first, the respondent's determination with respect to the first claim involving a schedule impact change order and the steel costs associated with the schedule impact lacked the determination made by CUNY, in this case the agency, by the Vice Chancellor, lacked any rational basis for failure. They failed to consider the language in the change order. And if I can get into the language in the change order.
But does the language in the change order supersede the language in the contracts?
It is part of the contract, Your Honor.
My question was whether it supersedes the language in the contract.
Yes, Your Honor.
Because you have contractual language, so you're saying that the language in the change order waived the written contract language then, because that's the only way we can get there.
Oh, it wasn't a waiver, it was part of the contract. It superseded.
No. That's your assessment, right? So if I'm saying to you, based on my reading of the contract, I don't agree with you on this issue, so then I can only say that then your argument is one of waiver, that because they added this language to the change order, they then waived the language in Rider B, Section 15.5, which says that the petitioner understands and agrees that escalations in cost of labor and or materials, regardless of the cost of that escalation, which would include a delay, including the contractor's delay, and the time of such such shall not constitute a change to entitle you to a change order or additional payment. So that's very clear in the contract language. So for me to get to where you want me to go, I have to then determine that the language in the change order waived that provision.
First of all, Your Honor, it can be construed as a waiver, and we've talked about the Plato case. However, before we get to waiver, we need to first look at how a change order is defined in the contract.
Okay.
And as we placed it in the record, and I don't have the actual page, Your Honor, but the contract gets into changes, and if there's a change in the scope or the manner and method in which the work is performed, and that's how it's defined in the contract, then the parties can enter into a negotiated change order. And so what they did in this instance is in this case, it had to do with cranes. There was a north crane and a south crane. The schedule anticipated that both cranes were to be working simultaneously, and they were supposed to work together for a period of time.
Right.
If the time extended to 3 months before or 3 months after, a change would be negotiated.
Right.
So what the parties did, and that included, by the way, work in the winter months in this instance, because the work was anticipated to be done earlier. So now we're in the winter months. Instead of starting in May, we're actually starting in, respectively, September and December, separate, staggered, not together. So now there's a change. And so what the parties did is, and they are entitled to under the contract, they negotiate a change order, which then becomes part of the contract. And obviously the language in the change order matters, because that's now contract language. So it's not a case really of waiving something that you had in the contract, because now you're adding to it. So when you talked about superseding, I agree with you. It did supersede. You've now added language to the contract through the change order that the parties are to abide by.
So I'm trying to understand, when you say you've added, are you focusing on the one line in the change order that allowed for payment of extra rental fees for the cranes? And I'm paraphrasing it. Any other additional expenses should be submitted under separate cover. Is that what you're arguing as a superseding claim to create an exception that certainly doesn't meet Carino, but an exception to the no damages for delay clause? Is that what you're saying makes you a winner?
Sure, I don't want to cut you off, if I may. Yes, Your Honor, this is not a Carino-Savetta exceptions. We're not talking about changing the court's position on no damages for delay and how no damages for delay exceptions are reviewed by this court. That is not we're not looking to make precedent. We're not looking to address the no damage for delay. What we're talking about is a relatively unique circumstance here where the parties negotiated. They chose to put the language, and the language you're talking about are the costs
One that I
under separate
what I
cover.
just paraphrased.
Those two, the lines exactly are, note, there are additional steel costs associated with this delay, storage and handling, winter erection, again, winter months, increased material costs, et cetera, which will be submitted under separate cover. Now, this was signed by the owner, it was signed by the construction manager, and by the contractor. Now, the reason why this is important is, and the only reason why it was under separate cover is those costs were not yet ascertainable. So we knew what the crane costs were, and those were added to the change orders. What the parties did is they added this language, and this language was added affirmatively. In other words, if it was just the crane cost, if it was just the upcharge for the crane cost, there would have been no reason to put this language in there. This language was affirmatively added into the change by the drafter of the contract, by the agent for CUNY.
How do we know that the reason that that language was added was in order to move forward because the contractor was trying to get agreement on additional costs that they didn't believe was covered, and so they figured, you know what, let's not fight about this now. We're gonna cover the cost of the additional costs for the crane rental, and we will fight about that later, submit your additional costs. Why is that not an appropriate way for this court to view that language?
In this case, Your Honor, they didn't even consider the additional costs that were submitted. So the point is.
But that's my point. They're saying, you're proving my point, right? So if from their perspective, right? If from their perspective, the only thing they had to give you was the increase in cost for the rental of the crane, the two cranes now, because now they're separate, right? So they had to give you that. And I'm sure as between these two parties, I could see how your side was saying, but we have additional cost, right? It's winter, that entails additional safety measures that cost me money, right? I get it. So from their perspective, they're like, all right, I need to keep this project moving. So we're gonna agree on what we know the contract says, everything else put, and we will discuss and figure it out later. Why is that not a reasonable way for this court to look at that?
Yes, and I can explain it, and that really cuts to the heart. It's an excellent question of how this is an irrational determination. Because the contract language, which is what this wording is now that you've added it to the change order, it becomes a contract that supersedes, to the court's point. The contract language must be interpreted to effectuate its purpose. What was the purpose of acknowledging and directing submission of additional steel costs if not for payment? Why would we be spending money, the public fisc, in reviewing costs, having the contractor submit the cost, having CUNY on public dollars reviewing these costs, if not for review and payment. Now, they may say we disagree with certain
Maybe
costs.
the stars and the moon align once in a while and they actually give you more.
Well, as a common sense principle and as a contract principle, if I were to say to anyone, any one of us, I need you to submit, we're acknowledging there are going to be additional costs, and in a payment document, a change order document, I take the time when I didn't have to write anything else. I could have not even mentioned these costs, not even referenced them, or I could have said it's a reservation of rights. This is subject to the contract provisions. I didn't choose to reserve my rights, which is what happened in Plato. Didn't happen here. Okay. There's no reservation of rights in saying this is subject to the contract. I didn't have to add this language to the change order because it could have just been on the upcharge for the crane costs. But what did I do? I affirmatively added this language to the change order, and I affirmatively signed off on that. So now we have to read it to determine whether or not this contract language, we can effectuate its purpose. If we're saying that they went through all the trouble to add this language for literally no purpose, to just appease somebody and mislead them, that's not the purpose of how an agency is supposed to act. That's not good faith in how an agency acts. It's not rational, it's arbitrary and capricious. Again, the contract language must be interpreted to effectuate its purpose. What was the purpose of acknowledging these costs and telling me to submit them for review, if not for review and payment?
All right. We'll have you on rebuttal.
With respect to the handrail, Your Honor, if I may, that's the second claim. Forgive me, I'm getting...
you have 30 seconds, and then the rest is on rebuttal.
I'll be very quick. With regard to the handrail, Your Honor, the trade scope checklist in the contract indicated that where there were temporary handrails to be installed, okay, the contractor is not responsible for stainless steel handrail and guard material, stainless steel handrails or handguard materials, okay, to install permanent rails. So in this instance, under the trade scope contract breakdown, the checklist, where they were installing temporary handrails, they were not to be installing permanent rails. Okay, what had happened in this instance, and these are the only two instances in this contract, but they're unusual in how this was approached by CUNY.
Counsel, I need you, you're out of time.
In this instance, Your Honor, on the handrails, okay, when the contract was bid, when the contract was approved, it was crystal clear to both the construction manager, to the contractor, and to the owner that this scope was not in the contract, the installation of permanent rails. It wasn't until it was placed into another contract and an architect answered an RFI that all of a sudden there became an issue. That was post-bid, that was post-award, and all of a sudden they said, no, this is somehow part of your contract.
All right.
Okay, thank you, Your Honor.
Thank you.
Good afternoon, and may it please this court. Anthony Radawatso on behalf of Respondents CUNY and Vice Chancellor Hector Batista. To get right to the schedule impact claim, it was rational for the Vice Chancellor to determine that petitioner was not entitled to additional delay-related costs here. The clear text of the two exculpatory provisions, the no damages for delay and the no escalation clauses, plainly prohibit these claims. And while petitioner...
So then why not just say in the change order that this is the only thing we're paying for as per the contract, and that's it? Why string them along to make them believe that there was going to be an actual consideration of these costs?
Certainly, and I can explain exactly where this language came from. If you look to the record at pages 427 to 431, you can see both the final change orders that were approved by CUNY, but the next page in these two change orders includes the proposed change orders from CME Construction, and you'll see, and it's on CME Construction letterhead, so you know they drafted these. It contains the exact same language. Essentially what this was a heads up from CME Construction that, hey, Owen Steel intends to submit additional costs for consideration related to these delays for future consideration by CUNY, basically. And this language was copied verbatim into the final change orders and simply signed off. But again, this language, it says additional costs will be submitted. It does not say additional costs will be paid. It doesn't say additional costs will be reimbursed. That simply is not enough to infer waiver here, and it was definitely rational for the Vice Chancellor to reach that determination. I just want to address the point. They seem to suggest that there is a different process here for change order claims under the contract. That is not the case, and I want to point you to section 6.9 of Rider B. That specifically addresses claims related to change orders initiated by Owen Steel, and it says they have to go through the normal procedures under Article 16 for a claim in dispute, and by their terms, both of these provisions, the no escalation and no damages clause, specifically refer to all claims and disputes under Article 16. If there are no further questions on the schedule impact, I'll go to the handrail dispute. So as to this issue, excuse me, the plain terms of item 145.
When was the material that was intended to be used for the handrails known to this contractor?
At the time they bid on this work, Your Honor. So to the extent...
So they knew at the time that it was steel carbonate, not steel?
Absolutely. And so item 145 was included in the scope of work that Owen Steel bid on. Item 145, as it does today, it specifically referred to the architectural drawings at that time. Petitioners cite no record support for the proposition that the material identified in those drawings changed in any way. To my knowledge, they did not. I will just briefly add here to the idea that this was an afterthought of the parties or this wasn't on their mind. Owen Steel is a sophisticated party. They were paid $29 million to do this project. They were hired to provide, the carbon steel infrastructure of this business. A separate entity was hired to provide, the stainless steel furnishings here. That's why the trade scope checklist clearly delineates between carbon steel and stainless steel. It is implausible.
Where in the record can I find that at the inception of this contract, the carbon steel was noted as the material that would be used for this railing? Where can I find that?
Yeah, to my knowledge, just nothing has changed. It's just the...
Counsel, that's not answering my question. You want me to go through technical contracts and find the winning document for you on my own. I'm asking you to identify where that document is, and if you can't tell me now, I expect you to send a letter to, listen to me now, to send a letter to this court letting me know where exactly in the record that document can be found. You are hinging your entire argument based on that was already in the contract. I accept that. Show me.
It's item 145, which is at page 137 and 782 of the record. Petitioners cite to no evidence that that has changed. It did not. That is the document that they bid on in this case. Again, it's 137 and 782 of the record, Your Honor.
Thank you. Had you given me that, we wouldn't have had that lashing.
And I just want to reiterate here, the standard of review is arbitrary and capricious. There just needed to be a rational finding here for the Vice Chancellor's determination. They looked at the language in item 145. They looked at the architectural drawings. They were consistent with this interpretation. That's all that is needed. Thank you.
Thank you.
I would note that...
Is he wrong that on the original document that you bid on, it noted steel carbonate for the railings?
He is wrong, Your Honor. 145, the trade scope checklist that he's referring to, does not get into steel carbonate. It says furnish and install railings as shown on the drawings and specified, including but not limited to the following. Note, and it goes right to note, where stainless steel handrails or guardrails are shown, this contractor is to provide...
Okay, so it refers to drawings. What do the drawings say?
Drawings are unclear on any particular material. And I can explain to you, and this is noting, he's mentioning the experience of this contractor. This contractor did not include permanent rails for those 10 straight railings that we're talking about. They didn't because it wasn't on the drawings.
Counsel, when you just read that portion of 145, you deleted all stairs. It says all stairs and furnishings.
Oh, yes.
Okay.
I thought I said that. Furnish and install all stair and railings as shown and specified, including but not limited to the following. And then they create an exception for the stainless steel. That's why I said note, and there's an exception where stainless steel is referenced. So in this instance, on the drawings where those railings were, there were stainless steel references and no references to anything else. Now, what happened was the contractor experience didn't include this in his bid. And it
Counsel, Counsel, you don't get to put your hand up at me and keep talking.
sorry. Yes,
Okay?
sorry.
Thank you. We have your record. We're gonna look at this
Can I
closely.
just know one thing on the other item?
No, counsel, counsel,
Fair enough.
thank you. Cutrone versus Cruz.
No, submitted.
Oh, I'm sorry, Owen, no, that was Owen Steele. Cutrone versus,
Submitted.
oh, that one's submitted. Rossi versus Doka. I don't have to submit on my document, so. Okay. You may proceed, counsel.
Good afternoon. May it please the court. Sarah Thompson of Biederman Honig Sempervivo for the appellant Doka USA Limited. I'd like to just, if I may, start by narrowing the scope a little bit here, not of the appeal generally, but just to draw the court's attention to the record, the summary judgment record below. Obviously, I apologize for the length of the record before the court. Obviously, this is a summary judgment case with a lot of defendants and a lot of claims at issue and a lot of testimony. The key piece of testimony here with regard to Doka's motion is that the plaintiff himself and various witnesses that were presented in the court below have offered testimony that the ratchet that is the subject of this litigation, that is the tool that plaintiff was using when he was injured, was reasonably safe, right? The requirement on a product liability case.
This is a tool that had to be replaced 10 times before this accident.
Allegedly.
10 times.
That's what plaintiff alleges, Your Honor.
No, that is what is confirmed even by defendant witnesses, that they had to replace this tool 10 times.
We don't
But
dispute.
continue.
No, we don't. You're correct. We don't dispute that there were ratchets on the work site that possibly could have been Doka ratchets that had to that were not.
All of the ratchets were, please, all of the ratchets were ordered from Doka. Doka provided the system and the ratchets. So let's be clear. We've read the record, okay?
I believe that there is some dispute as to that. There is testimony suggesting that the
whom?
ratchets, well, by the site supervisors, by Roger and Sons, saying that and by Doka's own people as well, that
I'm
ratchets
sure
do
Doka's
have to
saying
be
that.
ordered. Well, no,
I didn't see anybody else saying that.
the ratchets do have to be ordered as a separate component to the system. So for purposes of this argument, it's not my intent to suggest that, even if we assume for purposes of this appeal that that the ratchet he was using was a Doka ratchet, even if we assume that, and even if we accept that there were 10 ratchets that he personally had broken, that's not evidence.
I didn't say
there was
that. You said that.
Well, plaintiff testified to that, right? So that's
He
obviously.
didn't testify to that he broke 10 rackets. He didn't say that.
I believe he did testify that he personally had been involved.
That they had broken and he had to have them ordered by his supervisor.
Not in those specific terms, Your Honor.
And neither in your specific terms, but continue.
He's testified that this is not the first time a ratchet he was using has broken. Now, where that testimony is not is a little bit equivocal, is that he doesn't exactly know whose ratchets they were, where they came from, whether they were Doka's, whether he doesn't know, right? But for purposes of the injury-causing implement, we will not. We can assume that. Let's assume, arguendo, that the ratchet was ours, right? What I wanted to just highlight here is that there's the evidence in the record and what Doka has shown is that it was not unreasonably safe. The standard, unsafe rather. The plaintiff used the ratchet. He was using it. He was holding it in his hand. The ratchet itself didn't actually hit him. It didn't actually break and whack him in the knee. What happened is that and this is made more explicit in the testimony of his supervisor, Mr. Barrow, who talks about, well, when he also did this, right? He used his foot to gain leverage and increase
Several
support.
of the workers said they had
Correct.
to use it in order to get the instrument to work.
That's correct. That's what they say. It doesn't, those facts, I would argue, don't make it proper use of the product, right? I mean, I can drive 65 down the Palisades, and that doesn't make it right just because everyone else is doing it, right? It's still illegal. I'm supposed to drive 55. I'm still going to get a ticket. I can, we can accept that that's what other people were doing, but we also know from the record and from testimony of Roger and Sons.
That's very different. That you can't equate those two things. Here we're talking about something that wasn't performing the way that it should have performed. So they used other means to try to get it to work, and we're injured as a result. That's very different from you deciding that you want to speed down the Palisades.
We would argue, and I think it's very clear in the record and in the papers, that actually plaintiff was not using the tools the way he should have, and he admits to that. He actually concedes that he was supposed to have a partner. He had a partner, but he wasn't using his partner. And the only reason—
Fundamentally, to discharge your prima facie showing for your summary judgment motion, you need to make an affirmative showing that your product was not defective, that it was reasonably safe for its intended use.
That's correct.
Not just pointing to potential gaps in the plaintiff's evidence should the case go to trial.
That's correct. And what I would like to—
And so what evidence did you
I think
introduce to show that this was not a defective instrument?
Well, that it was reasonably safe would be the standard.
You're saying so is not proof. So what proof in the record is there that this instrument was reasonably safe?
The proof is the plaintiff's own use. The proof is the plaintiff's testimony that he was using the ratchet before.
You'll have
Proof
time
is
on
that—
rebuttal, because you've said all of this before. I'm sorry.
Okay, thank you. All right.
Counsel, who's first? You may proceed.
Terrence Cortelli for the plaintiff respondent. Judge, I think judges, for their summary judgment motion, they put in no evidence that the ratchet was reasonably safe. Now they're asking for us to adopt a federal rule saying, if they point to gaps in our case, we can't make it.
And that's not what our jurisprudence holds in this state.
For a number of years, Judge. So I think moving to, and there's ample evidence that these ratchets were breaking all the time, and it's in, Your Honor, the First Department's decision from a couple of years ago saying there was a lot of proof that these ratchets were breaking. I think what we'd really like on this record, we would like and I know it doesn't happen all the time, but we're asking for the First Department to search the record and grant us the 241-6 on the 2315 provision.
Well, in light of the evidence that, as your adversary just pointed out, your client was utilizing in a way in which it wasn't intended, that seems to foreclose a summary judgment finding in your favor, because it seems to me that it's up to a jury to decide whether that use was impermissible and was one of the reasons why he was injured. So I just don't see on this record, on either side, how we can grant summary judgment.
Right. Well, the only argument would be is there is an issue of misuse, because that's what they're saying all the time. But at least for us on the liability, there's a violation, it's not safe, and then they could come back, because it's a 241-6 case, and say, well, you know what, it's comparative as well.
Yeah, but it's not a 240-1 case where it's strict liability, right? So we have to determine to what degree and whether there is enough to say that we can comparatively split, or that one is more responsible than the other. My colleague, I think, has a question.
Just a procedural question. Did you appeal?
No.
So how can you ask us to grant you this kind of relief?
I understand. Well, the problem was they also made a 240 argument, a 241-6 argument at the Appellate Division, not at Supreme Court, saying they're not a labor law defendant. They never made that argument at Supreme Court. So by making that argument, I thought maybe it would open the door for us to say, you know what, they are labor law, and it is a 241-6 case.
Okay.
It's a stretch. It's not. It doesn't make it easy. And maybe one other issue.
Well, I appreciate that you recognize that.
And perhaps one other issue is, I understand they're saying it's a misuse. Nobody from their side put in, other than the attorney saying it's a misuse, and the gentleman in charge of safety for the general contractor says he did not consider it a misuse for using a ratchet, and the theory was when you're trying to change a ratchet on a tire and the lug nuts are frozen, you put your foot on it. That's what they do. Brute strength at a work site, that's kind of the way it happens.
Got it. Thank
So
you.
that would be, that's probably it. Go ahead.
Yes, thank you. All right.
Good afternoon, may it please.
Good afternoon.
May it please the court, my name is Timothy Keene. I represent all the other respondents, the defendant respondents. I'm talking
The
fast.
World
'cause
Trade
I
Center
was given
defendants, yes.
3 minutes, and I have 8 things to cover. Judge Michael, believe it or not, that 65-mile-an-hour thing, believe it or not, it's somewhat applicable because car manufacturers know people are going to do 65. So here, it's a foreseeable misuse. That's the commonality between the two. And
I think that is a stretch beyond words, but go ahead.
okay. All right. So let's just go very briefly to the brief. There's a spot in which we have addressed that plaintiff did testify that there was, I'm on page 10 of our brief. Doka argues that there should have been another coworker with him. Okay. Plaintiff testified, if it was a bigger wall, if there was more than one mechanism, I could work on one, I already have a light, and he could work on the other so the wall could go evenly, but it was one. That's on the, in the record at page 593. So there's no contest there. All right, where there is, Justice Sherman had raised, did you appeal? The answer is no, but I didn't appeal either. And plaintiff came to this court and asked that this court address the 241-6 issue. We are united on that. And I tell you very seriously, obviously this court has the authority to do it under Dunham. Everybody moved for summary judgment. The time, the judicial resources you save will be your own. This case was here, these two were here 4 years ago, 5 years ago, 2020 it was decided.
And you'll all be back again.
In 2 years, it seems.
We know this.
It's, well, what we're looking to do, this is a trial scheduled in a month, we all moved in the year 2020 for summary judgment on the meaning of this statute, of this industrial code regulation. The lower court did not address that at all. It is an issue for the court to address. What does this regulation mean? And we have gone through how this regulation, this particular regulation, is about the condition. This ratchet broke while the man was using it. If it was a broke ratchet, the reg could apply.
I don't disagree with you, which did not prevent either of you from moving so that the court could consider and the other side would have an opportunity to respond.
We moved. Everybody
Right?
moved. Everybody moved, Your Honor.
Here?
What we failed to do
I'm
here.
talking about here.
Well, so he was a respondent. He briefed this. I was a respondent. I responded. So it is fully briefed before this court. He's put in one page at page.
And yet, neither of you chose to appeal the issue before this court.
That is 100% true.
Okay,
Thank you, Your Honor.
thank you. You have a minute.
Your Honor, the only additional fact that I would just like to add, and what I was getting to when I was speaking about the evidence about plaintiff and his use of the ratchet as evidence that there was no problem with it. I just want to say, and I will rest, that the fact of the broken ratchets themselves, I think there's a lot being made about that issue, and the fact that there are other broken ratchets. I don't think that that is evidence of anything. I think that there's testimony, plenty of testimony from people that are not DOCA saying, well, his own foreman, plaintiff's own foreman said, yeah, we put broken ratchets in that toolbox where plaintiff pulled his ratchet from that day. So I can't leave here today feeling like I did something without just expressing that there is the fact of a broken ratchet is not evidence of a defect. It is not evidence of anything except that tools break. That's a fact. We don't dispute that. We don't dispute that things happen. We don't dispute even that they could be broken because of us. But the evidence that we have here is that that was not the case with this particular ratchet, even if it failed under the circumstances that plaintiff had chose to put it through.
Thank you.
I'll yield. Thank you, Your Honor.
Thank you. Have a good evening. Dwyer versus Dwyer.
Good afternoon. May it please the court, I'm Minette Hassapidis, appearing for the plaintiff in this action. Respectfully, the court erred in declining to enforce the termination of marriage provision of the PMA on the grounds that the court found it unfair.
Counsel, this action was pending, the 2013 action was pending for 10 years, right?
That's correct.
And your client did nothing to prosecute the case, right?
He did not, Your Honor. Clearly, it's optimal that actions be litigated more expeditiously, but the court found that this was not an abandoned action. The defendant had moved to have it dismissed. It was not abandoned. There was activity on both parties.
What activity and when?
I'm sorry. Plaintiff filed the summons with notice in August 2013. The defendant filed a demand for the complaint in October. On November, plaintiff served and filed the verified complaint. In December 2013, the defendant filed an answer. Plaintiff presented a proposed stipulation for settlement in 2015. In 2016, in an email, defendant acknowledged that the action was ongoing and had been ongoing for years. In 2019, and there is a gap of 3 years there, but in September 2019, she retained new counsel. So these are not—
Was that anything happening in court? Did counsel submit a notice of appearance?
No.
New counsel in 2019.
You know, Your Honor, I'm not sure that about a notice of appearance, but everyone agrees that new counsel was retained, and at pages 50 and 57 of the record, trial counsel for the plaintiff indicated that financial discovery was exchanged. So there was not a dispute in this fashion. And again, these are affirmative acts by the defendant here. I'm not spouting facts about what the plaintiff did, but this is two-sided. Nothing is concealed here about what occurred. Throughout the pandemic, there was no communication from defendant's counsel. And
because they were living together, right?
Well, Your Honor, let's be clear. They were not living together. They were living in a pod. And as my client testified, and the defendant did not dispute, even when they were in residences, because my client wanted access with the child, they slept in separate bedrooms. They had separate relationships. And Your Honor, to go back before this point, under the PMA, my client did not have to prove any of these provisions to trigger the termination of marriage provision. The termination of marriage provision said that the event occurred upon a couple of events. My client engaged in 2 of them. He separated and moved out of the marital residence in 2013 because of an extramarital affair by the defendant. Within a month, he commenced the action. So we have 2 triggering events.
And within the year of his leaving, he purchased a new home for himself.
That's correct, Your Honor. And again, that's not disputed. Under the agreement, it's an unconditional, unqualified, and unambiguous term.
Doesn't the law provide a direct answer to us here? Because good, bad, or otherwise, the law is, as far as I understand it, courts don't have any inherent power to dismiss an action pre-note.
Correct.
In order to dismiss an action, you have to point to a particular normative authority. So normally pre-note would be 3216, which requires a 90-day demand.
That's correct.
We don't have that. We don't have a 20227 dismissal for a failure to appear.
That's correct.
And 3404 couldn't possibly apply because that only applies to post-note cases. So using the word abandon is sort of imprecise to begin with, because abandonment usually connotes the case is post-note.
That's correct.
So cases can languish on life support for decades, unfortunately, but the way our procedural code is set up on the civil side, there has to be some, again, normative basis to dismiss the case. And I think the path here would have been 3216, or maybe agree to discontinue, but neither of those things happened.
Right. The defendant had it within her power to serve a 90-day demand, and she chose not to. And this court—
But the problem is that your client gets the benefit of the earlier termination date while having done absolutely nothing within 10 years to really evince that this marriage is over.
Your Honor, I would submit that the defendant is the one who greatly benefited by this delay. Under the PMA, under the prenup, she wasn't going to receive maintenance. My client has generously provided support for this family for the last 10 years. She has not had to return to court to seek pendente relief. If anybody benefited from this 10-year delay, It was the defendant. It was in her interests to delay the litigation of this action. It was not in my client's interest, and
Hence,
frankly,
perhaps why there was no motion to dismiss the action.
that's correct, because
Well,
she was
what's
receiving...
the difference between what she stands to gain in terms of like marital assets from a termination date of 2013 versus a termination date of 2024, or whenever the alleged new action was filed?
That's outside the record.
Okay.
As far as I know, I would say it is greater. It is greater. But if the PMA if the prenuptial agreement is enforceable, then certainly if she was operating under the assumption that this agreement would be enforced against her, it was in her interest to delay this for as long as possible. She has received unallocated maintenance and support for over 10 years. And again, I would be remiss, and I see my time is up, but I would like to point out that the court cannot intervene and evaluate whether or not the agreement is enforceable unless there is fraud, unconscionable conduct, coercion, or duress.
And there's been no
And there is-
allegation of any of those
There has been no concealment by my client. The fact that they got along while the action was pending should not be a penalty to my client. You would be sending the message that you have to engage in scorched earth tactics if there's a prenup to avoid claims like this in the future. And that is not the policy that should be espoused here when you have a litigant who has done the right thing. There was no need for litigation. He was trying to settle this in light of the plain terms of the PMA. I thank you for the court's
We'll
consideration.
have time on rebuttal.
Good afternoon, may it please the court. Matthew Napardi on behalf of defendant respondent Gina Dwyer. You know, I would submit to the court, how long was the plaintiff going to, as my adversary argues, do the right thing? If my client had not...
How is that an issue before this court?
Well, what I'm getting at, Your Honor, is that he commenced this action shortly before the 8th year of the marriage. Okay, he commenced it by serving a summons with notice. Then, a few months later, during the 8th year of the marriage...
Are we going to pretend like he didn't have a factual basis within a marriage to do exactly what he did?
That's right, Your Honor.
We're not going to pretend that.
Right, he had every motive
Okay?
to do what he did.
So
yes.
he had more, I mean, it's not like he woke up on, we're getting close to that 9th year, I better file those papers. No, he had a reason why he filed for an action for divorce that had nothing to do with him.
Well, I don't know
Right?
that. Your Honor, I don't know that. In fact...
Now, I don't know whether it's true or not, but he believed that that was the case, and so he moved forward.
Your Honor, respectfully, there's nothing in this record to support the notion that Mr. Dwyer commenced this action in 2013 for any other reason than to avoid the sunset aspect of the...
So you're saying that the allegation that his wife had an extramarital affair, which caused him to then file for divorce, is false? There's no, I mean, we have no evidence of this in the record one way or the other. All I know is that is what he believed, and on the basis of that belief, he filed for divorce.
Okay, that is what he
Right?
stated, Your Honor. You know, and I don't want to belabor that point because it's really
Right,
not
I don't think
relevant.
we should.
It's not relevant to my argument. So what I would say, Your Honor, is that the only way I see that my adversary could prevail on this appeal is if this court is willing to overlook everything that has occurred from the 2013 commencement date until Mr. Dwyer moved to restore the action in 2023. And just look at this.
Overlooking, it's giving the giving the contract between the parties its full meaning, right? Because he commenced an action in 2013, and that's the termination date based upon the prenuptial agreement.
Well, I hear, Your Honor, and I would submit that this case is not about contractual interpretation. This case is not about whether or not the premarital agreement is enforceable.
That's precisely the issue before this court.
I would
That is the issue before this court. Whether the court below had the equitable powers to, on its own, modify The prenuptial agreement that was entered into between the parties, which was unambiguous.
Your Honor, I would submit that that's not the issue, because this court in Mamet and Broder gave a clear mandate that the trial court in this case followed. What the court said in Mamet, this court said, a party cannot, quote, hold on to an action despite clear evidence of abandonment solely as a potential weapon with which to strike back in the event reconciliation
In
fails.
Mamet, there was a stipulation between the parties, wasn't there?
Yes,
Within the action.
There was, yes, but
That's not, we didn't have
case
that
here.
here.
that's right, Your Honor. We did not have that, but we do have the parties all agreeing that this action, they all believe the action was abandoned.
No, they didn't.
Mr. Dwyer did, Your Honor. Yes, and I'll point to where in the record.
It was an active case.
Well, he contacted the clerk's office or something like that to find out if the case was still pending. Is that what you're talking about?
Well, no, I'll point out that in the order to show cause that the plaintiff filed.
You are suggesting by what you're saying that he believed this was no longer an active case because he had abandoned it. Nowhere, anywhere in this record, does he at all concede in any way, shape, or form that he abandoned this action.
Counsel, what does it say in the order to show cause?
May I point? I'm going to point to where he says this at the record page 45, in connection with the order to show cause, Mr. Dwyer's affirmation states, upon information and belief has been administratively deemed abandoned by the court. And this was the first time in connection with this motion.
But that's different from him thinking that the action's abandoned versus him thinking because nothing was happening on the case that somehow the court was empowered to deem the case abandoned. Those are two very different things.
Well, the court did not, the court found by the parties' conduct, and the court applied the standard that this court articulated in Mamet and Broder, which is that you have to look at all of the evidence. And what the court did in this case is it said that the circumstances must be carefully examined. That's what this court said in Broder, to determine whether or not the prior action should be deemed abandoned and essentially a nullity. And what the court in this case did is it went through all of the factors. The court specifically said motive is critical.
The problem that you have here is even this judge said that the case was active. Even this judge said that. I don't understand your argument.
I don't see that as a problem, Your Honor.
You are arguing that her client abandoned the action and therefore he should be out, when the court whose decision is being appealed said that the case was active.
I mean, think about the precedent that we're setting.
No, let's not. We're not doing that. I think I've got your argument. Thank you, and we will consider your papers and the record. You have 1 minute.
Thank you.
I'd like to quote from this court's decision in Gottlieb. In the absence of inequitable conduct, courts shouldn't redesign the bargain between the parties merely because, in retrospect, provisions might be improvident or one-sided. There's no basis for the exercise of any jurisdiction over authority over this agreement to rewrite it. Second, at pages 233 to 234 of the record, my client's affidavit explains in detail the circumstances giving rise to his leaving the marital residence. Judge Manzanet, you were correct. It wasn't a placeholder, as the defendant claims. He gave specific details that lended credibility to it, and the defendant did not cite any reason why my client moved out of the marital residence. She didn't purport to give an explanation. Mamet and Broder are distinguishable. In the first place, there was no PMA governing them. In the second place, Judge Higgett, as you pointed out, in Broder, there was a discontinuance filed. There was no indicia that there was a live action there. That's why the second action was deemed proper. In Mamet, the action had been marked off the calendar because they were attempting a reconciliation. Unbeknownst to the wife, hence the fraudulent conduct. Unbeknownst to the wife, the husband returned to court and secured an order restoring the case. But he withheld it, didn't serve it with notice of entry until years later in order to obviate the wife's commencement of a second action, which would have allowed her to benefit from the new and more generous equitable distribution laws. Under those circumstances, this court intervened. But this was not intervening to deal with the terms of an agreement that was ambiguous. Actually unambiguous, I'm sorry, in this case. This was to right a wrong. There is no reason for the court to intercede and rewrite the terms of the agreement. I thank the court.
Thank you. Wesco Insurance versus Cookman Best Insurance.
Good afternoon, Your Honors.
Good afternoon.
Max Gershwire for the appellant, Wesco Insurance Company. This appeal presents an issue that's novel to this court, but that has been addressed by federal courts applying New York law and courts in many other jurisdictions, all of which have sided with Wesco's position. That issue is whether an insurer is precluded from establishing prejudice from late notice if it also denied coverage on grounds other than late notice. The courts addressing the issue have logically found that prejudice is indeed precluded because under those circumstances, earlier notice would simply have resulted in an earlier denial on those other grounds. Although Cookman argues that Wesco failed to establish that it would have denied coverage to Mr. Tom, even absent late notice, the record shows otherwise, namely in its disclaimer letter, the same letter in which it denied coverage based on late notice, it cited two other grounds for denying coverage. Although Cookman could have submitted an affidavit trying to explain why, despite that letter, it still would have provided Mr. Tom with a defense absent late notice, it failed to do that. So the only evidence in the record as to whether or not it would have denied coverage, whether or not there was late notice, is its letter. It is unambiguous. There's no argument in the brief, in Cookman's brief, explaining how that letter is in any way ambiguous as to whether it would have denied coverage on these other grounds. Alternatively, the court should find that the late notice defense fails because Cookman still had the benefit of timely notice of Wesco's defense and investigation from the timely notice that it was given by Mr. Tom. In the Salvo case that this court recently decided in 2023, which is cited in our brief, the court found a lack of prejudice under similar circumstances. Finally, although Wesco's other insured, the building co-owner, Mrs. Tom, is not an additional insured under the Cookman policy, that should not have any bearing on the amount that Cookman has to reimburse Wesco because the fact that Wesco defended them jointly did not in any way add to the expense of the defense. If there are no other questions, I'll wait until my rebuttal.
Okay, thank you. You have some extra time if you need it, okay?
Good afternoon, Your Honors.
Good afternoon.
Sheil Alipor of law firm Chartwell Law on behalf of defendant respondent Cookman's Best, or KBIC. Your Honors, the timeline in this case is undisputed. The accident in this case occurred in 2017. The lawsuit was filed in 2018. It was not until 2021 that KBIC was placed on notice of this loss. Approximately less than 2 weeks after KBIC was put on notice of the loss, KBIC issued its disclaimer letter. In its disclaimer letter, it set forth different grounds for its disclaimer. Chief among them was the late notice. But in addition, KBIC set forth different grounds. It also stated that its investigation was ongoing and that it reserved its right to amend its disclaimer or to change its position based on its investigation. Counsel pointed out correctly that this court has never held that holding multiple, including multiple grounds of disclaimer in a disclaimer letter, that an insurer is therefore then precluded from disclaiming on late notice.
And it sounds like a catch-22.
Correct, Your Honor. Based on the requirements under 3420, an insurer is required to set forth all grounds for potential disclaimer with particularity. Otherwise, they risk estoppel on those issues. So for KBIC simply to say, well, they didn't need to include them, it wouldn't be prudent. In addition, Your Honors, this court ruled not 6 weeks ago on a matter that's directly analogous to this case, 244 Madison. The facts there are directly on point with the facts here. And there, the trial court, which was cited to by the trial court in this case, the trial court found that the unreasonable delay in putting the tenant's insurer on notice was unreasonable, and it did prejudice the insurer. In addition,
What's the prejudice here? What are you
Your Honor,
claiming?
the burden lies with WESCO to prove that KBIC was not prejudiced in this case. Because the notice was more than 2 years, WESCO bears the burden of showing that KBIC was not prejudiced. WESCO has not carried their burden. In fact, KBIC has demonstrated the prejudice, that prejudice has in fact.
Well, they have pursued the defense vigorously from the inception. They obtained all the required discovery. Many of the people that you allude to, that you don't have a chance to talk to, they've already said they knew nothing, so there's no prejudice there. So what's the prejudice?
Well, Your Honor, we don't have access to WESCO's investigation.
They said
Well, they
will give
offered
to
it.
you.
They offered it on the condition that we withdraw our coverage defenses to the additional insured. So we didn't have access to those documents unless we conceded to their position. Additionally, Your Honors, Atlantic Cafe was no longer operating at the time KBIC was put on notice. KBIC had no opportunity to investigate the site location or to gather witnesses to see whether or not, memories may have faded from that point on.
Well, again, we addressed the witnesses issue. So you can add it again, but we have witnesses who say, yeah, we were around, but we know nothing. So there's not too, you can't change that.
Well, KBIC may have found other witnesses, Your Honor. We don't know that. But in addition, KBIC didn't have the opportunity to chart its own course in this litigation. So WESCO recently settled the matter.
Is that enough to establish prejudice? Because if that is enough, then prejudice is assumed automatically based on that argument.
Under 244 Madison, Your Honor, the cumulative effect of no longer having access to the accident location, no longer having access to the witnesses, and not having access to the investigation, that proves, although it is not KBIC's burden to prove that it was prejudice, it does demonstrate prejudice. And in fact, WESCO has not overcome its burden to show that that KBIC was not prejudiced. The sole surviving factor that WESCO has set forth is their offer to share investigatory materials, which they've never shared. And they've conditioned those materials on KBIC withdrawing its coverage defenses. Your Honor, if there's no other further questions, then we rest on our brief.
Thank you. You may proceed.
Thank you, Your Honor. Going back to the issue of the multiple coverage defenses, under 3420, only certain coverage defenses are precluded if they are not timely asserted, only based on policy exclusions and policy breaches. The two other grounds that KBIC included in the disclaimer letter were not either of those. It was lack of coverage under the insuring agreement and coverage priority. So in other words, there was no danger of KBIC being stopped.
That's just this case. What's the application to other cases?
Well, in other words, the court could limit its ruling to the effect of, hey, if you're relying on defenses other than late notice that are not subject to 3420, so they're not subject to any waiver, then that is clearly relevant in terms of whether there's an excuse, whether the carrier had to include those defenses in the letter. But again, even if it were the case that the carrier, for whatever reason, rightly or wrongly, thought that it had to put those defenses in the letter, why didn't they put in an affidavit in saying exactly that? The reason we put in these additional defenses was out of an excess of caution to make sure we didn't waive them.
Have you established that there's no prejudice here?
Apart from the point that I'm making now, yes, I believe so, because again, WESCO had and KBIC are completely united in interest in terms of providing a defense. There's no basis for establishing that Cookman would have defended or investigated any differently than WESCO. WESCO had they both had exactly the same incentive in investigating and defending. Also, want to point out this whole idea that Cookman was deprived of access to the site. That's not true. My client's insureds, the building owners, still owned the property, and as far as I know, still do when they were provided notice. They had every opportunity at that point to still go into the building and investigate the scene. And so, and again, the building owner didn't know about the accident until 2 years later. So even if they've given immediate notice, it would have been 2 years after the accident. It just didn't make a difference.
Right, the conditions at the time would have changed anyway.
Thank you, Judge.
Thank you. All right. Thank you. Georgievsky versus Robbins. You have 5 minutes.
Good afternoon. May I please the court? My name is Georgi Georgievsky. Before I start my argument, I had the attorney. He took $4,000 and disappeared. We signed 2 times retained agreement. I have an expert witness. She took $7,500 and disappeared. For that, I represent myself. First, the court dismissed the case because on the rule 3101D, which is a scope of disclosure. This rule do not mandatory need expert witness for the testify. This is just asking party who planning to have expert witness to disclose certain information, so court can see that this expert witness is qualified or no, also opposite party. That's the purpose of this rule. Second, if is another rule about expert witness, the court should give a base to apply this rule for this case. You cannot just say this rule, 3101 or something to explain, like you get traffic ticket, they tell you by this law and you park near hydrant. That's my point. Third one, the lower court has power and right to dismiss the case, but they still should give explanation why they dismiss, base which they can dismiss. And fourth one, the court should show the subject matter is beyond the understanding an ordinary jury, so testimony on expert who helped find it with the facts and that the respondent deviated from the standard of care, and this will cause for appellant injury. So the definition of the expert witness should apply for this case if it's so complicated. The skeleton of this case is we have a medical practitioner who worked outside the scope of his license. Right. He come with more than 6 diagnoses without exam, and he doesn't need exam. If you see on that exhibit 8, on exhibit 9, what is the consent, he said patient must bring his medical record. So that's mean he's not doing his podiatric job, but he's treating Lyme disease, which I was diagnosed many times. And I also submit documents where he is expert for Lyme disease. So it's no question that he is treating Lyme, and he doesn't deny. The dispute between me and him is he claimed that I have problem with pain, chronic pain in foot and ankle or veins or something like this. But all these claims he doesn't support by my medical record. I have over here, and the counsel of defendant can find that there is nothing about it. It's all misleading. So, last one about this is he broke by working outside of his license, committing fraud, claiming miracle medicine for all kinds of diseases. He has a U.S. Code Section 54, guilty of misdemeanor. He has another New York State Class A misdemeanor. He has also working with dangerous gas. It's another misdemeanor Class A. And by working out the scope of his license, it's if felony. So that's and there is another also by yeah, that's the same with the federal, on the state level, on the federal level, committing fraud. Plus, General Business Law 349, you see, it's additional civil penalty for consumer frauds against elderly persons. In that time, I was over 66. So that's the all breaking the law. Also, according to the CPLR 4504D, which I give this copy of this rule to the judge, proof of negligence, if he's working out of scope of his license, it shall be deemed prima facie evidence of negligence. Okay. So that there is, I don't need now the proof of these steps that he breached the duty, that the duties caused this. That's the ready to judge can send to the trial.
Okay, you'll have time on rebuttal. You see your red light. You'll have time
Thank you very
on
much.
rebuttal. Okay.
Yes.
All right.
Good afternoon. If it please the court, my name is Teresa Scotto-Levino. I am of Louis Joe's Avalon Vilas, and I'm here for Howard Robbins, the respondent in this. As far as this appeal is concerned, this is a matter that was on the trial calendar in March of 2023. At that time, in multiple appearances before the court pre-trial, the court was clear that for it to proceed to trial, plaintiff would have to have an expert, not only on the claims asserted, even if we assumed that there was prima facie evidence of negligence, but on the causation issue of his damages. Plaintiff claims a lot of damages that he needs a trial to prove that there's a causative element to this.
Your client is a very lucky doctor. Very lucky that he keeps on victimizing people without means. Okay? We're just very lucky that he hasn't killed someone yet. This is not the first time your client is before this court.
Correct.
And he is practicing in an area outside his expertise. It's an outrage what he's doing. And eventually the law will catch up with him. Eventually.
And respectfully, Your Honor, this is not the point of this appeal.
Yes, this man doesn't have the expert he needs to bring this full-fledged to trial. Luckily for your client, because the conduct of your client is an outrage. And I don't at all mean any disrespect to you. You're an attorney doing your job. I get that. Okay? I get that. But we've got this man ended up in a hospital from the treatment administered to your client that he had no business providing.
But that's the issue. The issue is that
he's a podiatrist. He is a podiatrist.
I am aware, Your Honor.
Okay. So I didn't understand from this record that he was treating his feet. Okay? So are all your legal arguments, I accept them. But we're not going to pretend like what's happening here is not an outrage.
I disagree.
Yes, I'm sure you do.
I do. And that's the point. The point is that he was sent to the hospital because he was exhibiting certain fatigue symptoms after the treatment.
He was unconscious after the treatment.
I disagree, and there's no proof of that. Again, we're talking about evidence.
And the treatment was what? Giving him ozone treatment?
Ozone therapy, correct.
Ozone therapy.
For Lyme disease.
There were
a podiatrist that gives that treats Lyme disease. You're disagreeing about just that baseline statement?
That's not the issue in this appeal, but yes, I disagree. Lyme's disease is mentioned in his record, as is herpes and a lot of different Epstein-Barr.
That's unnecessary.
I cannot.
Thank you.
This is done because it was this is his medical history. It wasn't something he made up. Plaintiff told him these things. This is not the issue. The issue is he was sent to the hospital that day because my client could not get in touch with the contact on his medical records. He sent him to the hospital. At the hospital, the excerpt, the only medical excerpt that plaintiff offers this court is that nobody could figure out what was wrong. That's why an expert, that's why he was told for more than 17 months that he needed an expert to say what his damages are. He claims memory loss. He claims the inability to keep bees. He claims that his prostate was enlarged because of this. He needs an expert to prove those things and the connection with those things, and there is none. And he is very outward on the fact that he has no intention of getting an expert. I have no idea about this $7,000 to get an expert, but I know that an attorney came in for him in March, on March 19th, 2024, just before the year was up, that the case would have been automatically dismissed.
Thank you.
He came in and immediately withdrew his counsel.
Thank you. You have 1 minute.
First was one person killed by this doctor, 2018. You can see the case, Dr. Robinson against city examiner Rosa. That's second. I have medical record over here. I can show you that I was not diagnosed, but since doctor saw that I have stroke. By my left side was down, my bluish speak. I was typical stroke. She was holding me 3 hours. Third one, what I want to say that we can apply res ipsa loquitur doctrine, theory, because first 2 treatments, nothing happened. Doctor was the same, patient, room, apparatus, everything was the same. So must be something, apparatus was under control, and the patient didn't contribute to this, and must be negligence. And what's happened, he has in his email that he said that my artery was clogged. What was clogged? That was air bubble.
Thank you so much. GMF 157 LP versus In Spirit. You may proceed.
Good afternoon. May it please the court. Karen Klein on behalf of Appellant GMF 157 LP. These 2 coordinated appeals arise from 2 decisions of 2 different justices, which, when read together, improperly foreclose appellant from any forum to maintain its trust claim, even though there has been no adjudication that that trust claim is untimely or not meritorious. Now, first, appellant GMF commenced an action in October of 2023 against respondents asserting 1 claim for breach of Article 3A of New York's lien law. Respondents argued that a prior action, initiated actually by respondent, IDC, contained some of the similar issues, and thus the trust action should be dismissed under CPLR 3211A4 as sufficiently related to that prior action.
Why isn't that a valid argument?
Well, for a number of reasons, Your Honor. First, there's 3 reasons. So first, Your Honor, the parties were not substantially the same. In the initial action that is now pending before Justice Bannon, that is a claim between solely IDC, one of the respondents, and GMF. In this trust action that was filed by GMF, that's a representative action on behalf of not only filed by GMF on behalf of all trust beneficiaries, and it seeks the claims not only against IDC, but also against Alex Chisi.
What I need to be clear here is the plaintiff, to avoid the liens and the grief with the subcontractors, paid them all off. In other words, despite the fact that he gave money to In Spirit to pay off the subcontractors, and claim that the money was misdirected and all that other stuff. The bottom line is the plaintiff paid off the subcontractors without prejudice to trying to recoup that money from Inspirit, correct?
Plaintiff did, yes, a plaintiff
Okay,
did pay off
so-
subcontractors.
And that is part of the first action that was now before Judge Bannon, right?
So there is a portion of plaintiff's claim that is before Justice Bannon in terms of the subcontractors. Plaintiff in the action before Justice Bannon is seeking a total of approximately $17 million for a variety of issues, all breaches of contract relating to deficient construction work and other harms that have resulted. Out of that amount, there is about $200,000 relating to subcontractor payments. And I'll direct the court to page 141 of the record in the trust action, which sets forth a computation of damages. So there's about $200,000 that relates to subcontractor payments that we're seeking in that case. In this case, the trust case, there is a total, we have pled a total of approximately $900,000 that we're aware of potential damages relating to the trust claim. However, under the lien law, there's other remedies available to the plaintiff, which we're seeking here as well, including an accounting, including disgorgement and disbursement of trust proceeds, and we're bringing it not only on our behalf, but on behalf of others who may not have been paid. We just don't know because we don't have the records, right? And one of the problems is that they didn't keep the records.
You paid the subcontractors who weren't paid so that the project could continue. So don't say we don't know who else wasn't paid. You know exactly who wasn't paid, and you paid them so that the work could continue.
In part, Your Honor, in part we did. But the remedy we're seeking is not solely what was not paid. So under the trust law, the damages are based on the diversion, right? This is a diversion that we learned of in 2023 for the first time. It's not part of the claim.
Wait. When did you pay these subcontractors?
So we paid.
Answer my question. When did you pay the subcontractors?
I don't believe that's in the record, but I believe it was sometime between 2020 and 2021 that there
It was before 2023.
Correct, but diversion is not non-payment. So for example, the IDC could have received funds.
I thought that was precisely what you were alleging. We gave him the money for the subcontractors. He kept it in his pocket, didn't pay the subcontractors. I had to pay it again. I thought that was exactly what you were saying.
That's a portion of it, Your Honor, but diversion is not solely, for example, having the money and paying it for other project uses. He could have paid it for other project uses.
Or he could have kept it in his pocket. I'm not focused on what else he did with the money.
Right.
What I'm focused on is that your assertion was that that money was improperly used, whichever way they used it, and that you then had to make it whole in order to make the subcontractors continue to work so that they would not file liens and stop your project, right?
Yes, Your Honor. However, one aspect of the trust claim, one element of the trust claim is actual diversion, not solely holding on to it, but actually diverting it for another purpose. We did not discover that until 2023. That is why we did not bring the trust claim until 2023. As soon as we found out about that, and we learned about that in discovery, when one of
So are you saying you had to know where money was diverted to before you could bring a trust claim? The fact that money was missing and not accounted for wasn't enough to assert the claim?
Well, Your Honor.
Because I saw in your brief, you made the argument, well, we didn't bring the claim because we didn't have proof. But you don't need the proof. That's what the whole process is for,
I agree with that, Your Honor. I agree we don't need the proof in order to bring the claim, but we can also make a decision about whether or not to bring a claim based on what proof we have at the time.
And then we can make a decision about whether that was done in a timely fashion or not in light of everything you knew and could have done, right? So you make a strategic choice not to bring the claim because you're waiting to get the proof or for whatever reason, whatever. I'm not going to assume I understand all the strategy behind the reasons, right? But for whatever reason, you knew that this was a potential claim. There's no question about that, okay? The issue, according to your papers, is we didn't have the proof, so we didn't bring the claim. That's basically, in a nutshell, your excuse in your papers.
But there's multiple additional legal arguments, Your Honor, if I may just briefly. I know my
Please.
time is close
No,
to,
go
close
ahead.
to running out.
Look, we're the last ones, so we don't have to torture anybody else but us. Go ahead.
Thank you, Your Honor. Let's take the Justice Cohen case just first, right? So you have the identity of the parties, you have the relief sought. Again, there's additional relief that we are seeking in the Cohen action that is not being sought. I don't think that's up for dispute.
Right.
And then you have the fact that even if 3211A4, even if the standard is met, and we've argued that it's not met because the relief sought is different, among other reasons.
Okay.
Even if it's met, the court has to consider making an order as justice requires. So it's not just they dismiss it if the standard is met, but courts routinely, as we've set forth in our brief, to stay or consolidate cases when it meets 3211A4, but the interest of justice so requires. And so in our view, that's what the court should have done. If I may just very briefly address the Bannon action, I know that.
I'll give you another 45 seconds, and then you'll have time on rebuttal, okay?
Thank you, Your Honor.
All right.
So the Cohen decision specifically said, this is without prejudice to bring it before Justice Bannon. When we brought it before Justice Bannon held that it was delayed and prejudicial. Now, I know we've talked a lot about delay, right? But delay alone is not sufficient. There has to be significant prejudice in order to deny a motion to amend. There has to be significant prejudice. There is no prejudice here. The respondents have speculated, well, maybe we would have done things differently, maybe we would have retained different counsel, maybe people forgot about things. We've cited many cases throughout our brief that say that's not sufficient. You need to show actual significant prejudice, and without prejudice, there has to be, the amendment should be permitted.
To what extent do you have a tougher road to hoe under 32 or 3025B because it was a post-note amendment and it was a sort of an eve of trial amendment where there is law from this court and others that say leave to amend should only be, should be granted with great circumspection under those circumstances?
Thank you, Your Honor. So it still is, this court still considers, even under those circumstances, and still requires there to be prejudice. And so you look at the context of the case, and I'll direct the court specifically to this court's decision in Jacobson, the second decision we cite from 2013, which was post-note of issue, and the amendment was permitted, and as well as the Kimso case, which is a New York Court of Appeals case, which was actually post-trial. And so that does not foreclose there being an amendment solely based on the stage of the proceeding. The court still must consider prejudice, and here there simply is no prejudice.
Thank you. You'll have time on rebuttal.
Thank you, Your Honor.
I think I can be the first person to say good evening, Your Honors. I think
Good
we're at
evening.
that point.
Yes.
Derek Moore from Bailey Duquette for the appellees in both appeals. May it please the court. Both appeals involve the appellant, GMF, the owner of the premises, belating seeking to add a new trust fund diversion claim that brings in Mr. Chiesi, the principal for the former general contractor in Spirit Development, in his individual capacity, despite the fact the appellant had knowledge of all the necessary facts supporting this claim from the very start of the underlying action. With regards to the new action that was filed in late 2023, the trial court properly exercised its broad jurisdiction or broad discretion under 3211A4 to dismiss the new action because it was based on the same project, the same premises, predominantly involving two of the main parties, GMF and IDC. As this court has acknowledged repeatedly, the key critical question is whether the second action arises out of the same subject matter or series of alleged wrongs. It certainly does in that case, given the fact it is the same exact project with the same exact project participants. With regards to the motion for leave, the trial court properly exercised its discretion by denying the motion. As this court has acknowledged, where there has been an extended delay in moving to amend, the party seeking leave to amend must establish a reasonable excuse for the delay. GMF does not have a reasonable excuse. In its initial answer in August of 2020, it alleged that Inspirit did not pay the subcontractors. In April 2021, it sent a lien law demand to Inspirit, clearly listing off the same exact subcontractors and the same quantum of damages that it eventually put into the future claims. And GMF, in its new action, even alleged that it knew in late 2019 and in early 2020 that IDC had not paid its subcontractors with the funds paid to it by GMF. Therefore, GMF was no doubt aware of this claim and just chose to keep it in their pocket until years later.
So let me play devil's advocate.
Fun.
The same way that they knew this claim existed, so did you. So what's your prejudice?
I think there's sort of two things we can talk about, Your Honor. So I think first, we can talk about the fact that Mr. Chasey, who has not been a party for a significant period of time.
Yeah, but he's the owner of Inspirit, so he would have been all up in what was happening on the case against Inspirit. So
I do agree in certain capacities. However, he went through all the discovery as a corporate representative, which is a very different situation than if he was going to be deposed in his individual capacity, especially if there's in a scenario where he might have different situations than the corporation when he's got employees who are handling many of these things along that nature. So I believe that is certainly some prejudice.
Okay.
But I also want to talk about the fact that this court, so very recently in the Heisler, Heisler, versus Advanced Dermatology case, December 5th, 2024, they acknowledged that a late filed complaint without a valid excuse should not have been allowed to be filed. And they concluded, they kept going to say, this conclusion holds especially true here where plaintiff knew the factual basis for the proposed pleadings at the beginning of the action. This court has specifically stated that when you have the knowledge at the very start of the case, you already have the full knowledge, and therefore there is no reason why you should be delayed years in order to bring the claim. Unless there's any other specific questions, I'm happy to cede my time.
thank you.
Thank you, Your Honor.
I'm gonna give you one of his minutes he left over. Because I know you want them, so go ahead.
Very, very briefly, Your Honor. Thank you very much. I just want to say, I didn't hear anything that actually shows any prejudice, right? There's no specific mentions of prejudice, as there must be for denial of a motion to amend.
If I heard your friend correctly, he said the precondition at this procedural juncture to getting leave to amend is a reasonable excuse for the lengthy delay.
Your Honor, I don't disagree. I don't agree with that. That's not what the case law says. The case law says that you get to amend unless there is both an unreasonable delay and prejudice. And I'll point the court to Kimso, to Jacobson. Mere lateness enough, whether reasonable or not, is not enough to deny a motion to amend. There is required to be prejudiced. Here, there is no prejudice.
So you're saying on the eve of trial, in every case in this state, you know how that would shut down our court system to a halt? I understand you want to make an argument, but we have to consider what the impact is going to be on the ground to the courts. So if we were to hold that unless a defendant can show absolute prejudice, notwithstanding how long the delay is, no matter, even when the first witness is about to take the stand, this has to be permitted? I can't imagine that our case law would support that proposition. So there's got to be something in between those two extremes that is the right way to go.
Your Honor, the New York Court of Appeals in Kimso specifically said, delay alone is not enough, absent a showing of prejudice. Now, there is a delay that could cause prejudice if we're talking about taking different legal strategies. There are cases, for example, cited by Respondents' Counsel where there were legal strategies undertaken as a result of reliance on certain representations that were now seeking to be changed or withdrawn. Those could be prejudicial. But here, however, there simply is no prejudice.
Is there any additional discovery that would need to be undertaken if the claim was permitted?
If there is, it's quite limited. I'll note, however, the court in Jacobson, this is the 2013 Jacobson decision that we cited, says, and I quote, "The need for additional discovery does not constitute prejudice sufficient to justify denial of an amendment." And that's a post-NOI case. And so that clearly alone is not sufficient. I will also just note briefly the point about Mr. Chisi being an individual. That has nothing to do with the conduct of the case. It has to be, prejudice means a harmful impact on your ability to present your case, on your presentation of the case, on your development of your case, not merely additional discovery, not merely delay. That's simply not what it is. And I also just want to note for the record, I know it's in our papers, but in this whole timeliness point, on the lien law claim, the statute of limitations on that claim doesn't even begin to accrue until the construction project is completed. That project was not yet completed in 2023 when we filed our lien law claim, which means the statute had not even started to run. So all this talk of delay, and I understand there's talk of delay and should be brought earlier, but just to put things in context, Your Honors, this was a case brought by IDC. So we terminated, a plaintiff or appellant terminated IDC as contractor March 12th, 2020, on the eve of COVID. Respondent IDC filed against us, filed against GMF 2 months later. We filed our counterclaims while the world was still shut down, and then proceeded into discovery. This is not a case where we are sitting here electing to bring some claims and not others and game the system. That's not what happened, Your Honor. We filed our claim before the statute even started to run. Thank you.
Leave that, forget it.
Thank you.